Yes, sir. ಇಲ್ಲ ಅಲ್ಲಿ ತಗೊಂಡೋಗ್ಪ. ಯಾರು ಇಲ್ಲ ಬನ್ನಿ. ಆಂಟಿ ನಾಳೆ ಬರಲ್ಲ ಅಲ್ವಾ? Tomorrow, 3 p.m. in powered by Puja. Yeah, I will cheer you up. Behind. Bro, full dandruff is coming. Wow.
Hello, court officer. Court officer. Court officer.
ಮೆಮೊ ಕೊಡ್ಲಾ
ಸರ್ ಕೋರ್ಟ್ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ
ಸರ್?
ನಮ್ದು ಮೂರನೇ ಲಿಸ್ಟ್ 44 ಸರ್. ರೀಚ್ ಆಗುತ್ತಾ?
ತಗೊಂಡ್ ಬಂದ್ಬಿಟ್ಟಿದ್ದೀರಲ್ಲ ನೋಡ್ತೀನಿ ಅಂದ್ರೆ ಹೇಳ್ಬೇಕು.
Sixth, sir.
ಯಾಕೆ ತೊಂದ್ರೆ ಕೊಡಲ್ಲ?
ಕೆಳಗಡೆ ನಂದು ಅದು 6
ಸ್ವಾಮಿ ಕೋರ್ಟ್ ಹಾಲ್ 3 ಅಲ್ಲ
ಎಜುಕೇಶನ್
ಸರ್? ಇದರಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 44 ಮೂರನೇ ಲಿಸ್ಟ್ ರೀಚ್ ಆಗುತ್ತಾ? ಹಲೋ, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಕೋರ್ಟ್ ಆಫೀಸರ್?
ನಾಳೆ ಬರಲ್ಲ ಸರ್. ಓ, ಅದು ಹೇಳ್ಬೇಕು. ಎಲೆಕ್ಷನ್ ಮ್ಯಾಟರ್ನಾ?
ನೋ ಕಾನ್ಫಿಡೆನ್ಸ್ ಮೋಷನ್ ಯಾರು ಮೂವ್ ಮಾಡಿದ್ದಾರೆ.
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ಇದ್ದೀರಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್
Came to 140 or 2 o'clock.
Oh, okay.
Yeah, came out of that.
Huh.
So I sat there, took the file and took the file. Neither. Everybody left and Sandeep came. Sandeep came, picked up the file. Then I took the file. So there was some fresh file remove ಮಾಡಬೇಕು. Total one. 4 o'clock. Submission ಮಾಡೋಣ.
How was this? What did you do?
Not 4, 5. Huh?
What did you do? Go there and do?
They all went.
Putting writing.
They all went for a trek. I didn't.
You went there only to sleep.
So I don't know. I didn't get to sleep. Yeah, so they all got up at 7 o'clock. They went for a trek. But below road also, like to climb the fund and all.
Today you have a heavy day.
But I have to go back to office. Tomorrow is the end.
ಇದು ಸೂಪರ್ ಇದು.
Tomorrow is a 3 days. 4th and 6th. Then I went to yeah, I'll show you. But the shirt, it's got sold. So she said, come, on the 15th and get some news.
What will you? Your place?
I think that's. Nobody.
Huh?
I mean, Harish, then Pramod, then Ravindra. They all knew beforehand that he wouldn't be here, so they all planned the temporary. Yeah. They have to all right. Don't move even on the sixth. Have it. Yeah. I have to check whether I can do the fighting. Judge, what is this? Let's say, she may. Your,
Because it's a
that's your
direction.
custody. Yeah.
Directions are in court, no, it got discussed.
Oh, staying on. Then you make a mention.
Yeah,
that
like a-
there's a-
I
let
got
it be-
it also. That's fine.
No, Pratima, you just say, let me list it tomorrow. The chief, the board feels that the board is.
I know.
then I. ಇವತ್ತು ಮತ್ತೆ ನಾನೇ. You know, ನಾಳೆ ಇರ್ತಾರೆ. Chief Justice conference ಇದೆ. Yeah, that. Oh, yeah, no, but he's from Bangalore or Dharawal. Good enough for the series. This is 2 years. Who is that district? Ah. Ah, yeah. ರಾಜೇಶ್ ರಾಯ್ ನನ್ಗೆ ರಾಜಶೇಖರ್ ಅಂತ ಹೇಳಿದ್ರು. ಬೇರೆ ಇಲ್ಲ. You can ask her when she gives. Take it after 10th and 10th of February, no? Yes, but they will put you. Oh, they'll give you, make a request. The Kiran. She gave. And then now, after 10th, huh?
Yes.
There was one. I think they're missing them, we cannot do anything here.
About 5 months left.
Okay. Last time, matter pertaining to portal number 1, my lord. The fresh matter to be tomorrow.
What is the urgency for tomorrow?
Agency, my lord, the collect is the president of the Gram Panchayati. The assistant commissioner has issued a notice calling a no conference commission meeting on 5th. So the said notice is challenged. May be taken up tomorrow.
Let it be moved tomorrow before the appropriate bench.
If the meeting is conveyed, my lords, my whole appeal itself would render.
Yes,
My lord, may I make one mention, my lord?
just a moment, please. Please make the submission there.
Please
There,
tell that
there,
appeal
there.
is filed against that. Give the appeal number.
Yes,
This is concerning Kotal 1. There is a direction by Supreme Court that the matter needs to be disposed of within 6 weeks from the date of the order. And I have attached the date order also. Can it be listed tomorrow or day after?
is it not better that you move it tomorrow before the
Because there's a
regular
time
court?
frame, that is the reason I just didn't.
It is so.
All right.
Please do it then.
I can.
Yes,
Please, my lord, this is pertaining to the court of record matter. That is all the records of the Honorable High Court. About last week, they have been trying to dispose of for destruction, my lord. I have filed a public interest litigation showing that destruction should be saved.
please move it tomorrow before the,
No, because
Appropriate
urgency is that because the matters were, they have already,
not going to be destructed tomorrow.
no, because they have already sent it for destruction, my lord. That is, the bundles which were there, hundreds of bundles have been sent. And my only apprehension is that it should not be destructed tomorrow, my lord. Because already they have sent it. Therefore, I'm saying 2:30, your lordship may kindly get the instructions from the information from the
Yes,
registrar, my lord.
tomorrow. Yes,
My lord,
just a moment. Yes. Just a moment, please. Yes,
my lord,
yes,
my lord, serial number 4. I appear for petitioner. I have
yes,
informed the
yes.
other
Just please wait. Please wait. Page wise it will be called.
much.
My lord, number 3.
No, please tell us if there's any matter which needs to be addressed today. Otherwise, it will come before the regular court.
Serial number 9, my lord, I'm seeking for grim order. In list number 3, serial number 9.
Can we just pass it over and see? Pass over. Let's see.
Lord, list.
There's a
Yes.
urgent requirement for today.
Yes.
Otherwise, we'll
Similar intermodal was already granted by the portal number 1.
let's see.
Lord, list 3, serial number 55, my lord. Memo of withdrawal has already been.
Just please wait. Yes, this is the provisional list. Anything else?
Third list.
55 in this list.
Third
list.
list. Withdrawal. Memo is already filed. List number 3, serial number 1, my lordship. Press for weeks time.
Just a moment, please.
Serial number
55.
I'm sorry. 51, yes. There's an urgency, only this thing is, father has not been giving consent for admission and
That
that
order is
clause
stayed.
is,
That order is stayed, Your Honor.
that order,
Yesterday, on Saturday, it was stayed.
I'm not aware
And-
of that. Yes, sir.
Serial number 54 is.
Serial number 24.
The dates are to be given by that court, please. We'll just simply adjourn the matters. Anything else which,
My lord, list number 3, the serial number
please,
4, my lord.
please wait, counsel, please wait. Yes. 43. Hmm. Hmm. Yes, yes. Only those matters which are being mentioned as being urgent will be taken up. Others will be adjourned to. Yes, yes. Not today, not today. Yes, it can be. Please list it some date next week. Yes,
When, madam, 16? 16
next
is
week
being
it will be.
mentioned. Madam?
the-
16.
Yes,
Let's list 3, Malad. May I make it?
yes, list 3.
List 3, serial number 16 and 57, Malad. 16 is vacating of interim, my suspension order was challenged. Interim order is vacated, against which writ appeal was filed. It is posted to today for consideration of interim prayer, Malad.
Already mentioned, it will be listed before the, the dates will be given by the other court.
Malad,
Next
it
week
is my writ appeal, Malad. I was not even informed. Malad, my vacating interim order is, I'll request the other side, Malad, to be present, Malad. Could it please be heard, Malad? My interim order which was granted is vacated, Malad. I'll request the other side.
Today.
It is at their request, it is posted to today, Malad.
My lord,
Listed before that court.
list number 4.
57
number
also,
three.
Malad.
During the course of the week, please list it before the other court. Yes.
Malad, serial number 57 also, I had mentioned it day before and your
Yes.
lordship had listed it.
Yes.
My lord, list number 3, serial number 4, it is a date given matter, my lord. No urgency by the other party in person has filed this appeal, my lord. List number 3, serial number 4, my lord.
Yes. Dates will be
And
given by that. Yes.
Date may kindly be granted, my lord.
Date will be given by the appropriate court. Yes.
Last of the list number 3 can be listed in appropriate court, lordship. List number 3.
Dates will be given by the court. Yes.
Oblige, lordship.
I know one small submission. List number 3, serial number 2, interim order may be kindly extended.
Yes.
Serial number 4, my lord. Kindly have it on next week, madam.
My lord, serial number 6, my lord. I'm for the respondent.
Wait, did you not hear?
Oblige,
This
oblige.
First page and it's 1 to 4.
Okay.
Yes.
But serial number 4, I appear for petitioner in court. Serial list number 1. May I request for 2 weeks accommodation? I have informed the other side also, my lord, because I have hurt my right hand. So therefore, I have informed my other side also, my lord. H.C. Shivramu and
Being
myself.
substantially implemented acquisition of the 1960s. Yes.
Yes. 2 weeks, my lord. 2 weeks, my lord. I have informed the other side also.
Weeks as a last chance.
Much obliged, my lord.
Serial number 6, my lord.
Yes.
I'm for the respondent. Your lordships had directed us to file a few documents on the last occasion, my lords. We've applied for it. Kindly, it may be adjourned for. 2
Just
or
for
3
you
weeks.
to produce documents if you want to. 1962 grant,
We've applied.
cancelled
my-
in 1981,
Yes, ma'am.
sold in 1992.
Yes, my lords. We have applied for the documents. An adjournment may be given, my lords. We still haven't procured the documents. My lords, we will definitely produce, but we still haven't procured the documents, my lords. Kindly, a date may
That
be
to
given.
the 61 grant. Yes. This, after a week,
Oblige.
at the request of the learned counsel for the respondent.
My lord, serial number 21. Appearing for the appellant, my lord. There is.
Final hearing. This is the part heard matter. No, 22 is final hearing.
There is some inconvenience.
22 is final hearing.
21, my lord.
21,
Yes,
okay.
kindly grant the week.
Of case on merits. Have you informed the other side?
Yes, ma'am.
And advocate are 1 to 4.
My lord, serial number 22,
Yes.
it's pending for the complaints. That is what the list says, but actually the
Pending for what?
complaints, madam, my lord.
22 is a final hearing matter. And it is part heard.
No, my lord.
Yes, it is.
No, 1448, 14448 of 22.
Your. Yes, when do you want it? Have you informed the other side? Have you informed the other side? No, there are others, Investec Builders and Developers, R2, R3, R4. Please inform. Yes. At the request of the Land Council for the appellant.
Your lordship, serial number 24, your lordship.
You have to appear, counsel.
Your lordship, my
We
health
cannot.
is-
No, I'm afraid we can't permit submissions when nobody appears. Which is why we have video conferencing. Please appear.
The respondent statements.
Who appears for the petitioner? Nobody is appearing. PF not taken. Acknowledgement of serving copy. It is a guardianship matter. Yes. There is no appearance for the writ petitioner. It appears that the notice that the PF to take out notice to R3 to R6, which was ordered on 14/2/2024 and thereafter on 24/1/2025, has also not been paid by the petition. On the merits of the matter also, the dispute appears to be a guardianship dispute, which has to be agitated in appropriate proceedings.
Yes.
We find no merits in this writ petition. The same is accordingly closed. What is the situation
Lord, we are,
with the mother?
no, it's not the child. It is the husband who has filed a complaint about the wife having gone missing.
Item 1,
Yes,
are you sure?
yes.
Item 1 is with regard to the child. Item 1 is with regard to,
Yes,
just a moment. just a
child
moment.
is come, Lord. Child is here. I'm sorry.
Legally solemnized.
Now child is with the father.
Thought maybe we had.
I'm sorry, my Lord.
Child is with the,
Father.
the child is also here.
Yes, Lord.
Yes, the respondent. Who's, what is your name? What is? Yes,
It is father's petition and he has the custody now. Yes,
it's about-
there is nothing. The mother is not present. It appears, yes. It appears mother has left the child with the father now.
I see. It is further submitted that the respondent, who is the mother of the child, has now given the custody of the child to the father who has filed this petition. The petitioner as well as the minor child,
Yes,
they present before us today. Properly identified.
Lord,
Properly
now they
identified.
reach the court.
Childs also? बच्ची का कोई identification है?
ಮಗುದಿದೆಯಾ ಮುಂದೆ ಕನ್ನಡ ಬರುತ್ತಾ ಕನ್ನಡ ಬರುತ್ತಾ ಮುಂದೆ ಬನ್ನಿ ಮಗು ಆಧಾರ್ ಐಡೆಂಟಿಟಿ ಮಗು ನಿಮ್ದೇ ಇಲ್ಲ ಆಧಾರ್ ಕಾರ್ಡ್ ಇದೆ ಮನೆಗೆ ನಿಮ್ ತಂದೆನೇನಾ ಇದು ತಾಯಿ ಎಲ್ಲಿದ್ದಾರೆ ತಾಯಿ ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೆ ಇದನ್ನ ತಾಯಿ ಹೆಸರೇನು ಗಿರಿಜಾ ಸ್ಕೂಲ್ ಹೋಗ್ತಾ ಇದೆಯಾ ಯಾವ ಸ್ಕೂಲ್ಗೆ your school is there? She does attend school. She identifies her mother. Her mother has gone for work, and the mother who has left the child with the father is she says.
In the above view of the matter, we have required the identification of the petitioner. And have Hi, Kushi. How old are you? 8 years.
No, she was with her mother.
His mother is also
her
with-
mother. Now they're together.
With the child, that's what she says. Let the child.
ಯಾಕೆ ಗಿರಿಜಾ ಅವರು ಕೇಸ್ ಹಾಕಿದ್ರು
ಫ್ಯಾಮಿಲಿ
ಅಲ್ಲ ಈಗ ಹಾಕಿರಲ್ಲ ಕೇಸು
ಈಗ
ಇದ್ಯಾಕೆ ಹಾಕಿದ್ರು
ನಾವು ಮಗು ಒಂದು ಸ್ಕೂಲ್ಗೆ ಹೋಗಿಲ್ಲ ಫೋನ್ ಮಾಡ್ಕೊಂಡು ನಮ್ಮನ್ನು ಕೇಳ್ತಾ ಇದ್ರು
ನೀವು ಒಟ್ಟಿಗೆ ಇದ್ದೀರಾ
ಒಟ್ಟಿಗೆ ಇದ್ದೀವಿ ಇವಾಗ ಒಟ್ಟಿಗೆ ಇದ್ದೀವಿ
ಸ್ಕೂಲ್ಗೆ ಹೋಗಿದ್ರೆ ಫೋನ್ ಮಾಡಿ ಕೇಳಿದಾರು
ಸ್ಕೂಲಿಂದ ಫೋನ್ ಮಾಡ್ತಾ ಇದ್ರು ಇವ್ರು ಕರ್ಕೊಂಡೋಗಿ ಊರಲ್ಲಿ ಬಿಟ್ಬಿಟ್ಟಿದ್ರು ಅವಾಗ ನಾನು ಕೇಸ್ ಹಾಕಿ ಮಗು ಕಾಣಿಸ್ತಾ ಇಲ್ಲ
ಗಿರಿಜಾ ಕೇಸ್ ಹಾಕಿದ್ರು ಒಂದು ಲಾಯರ್ ಇಟ್ಕೊಂಡು ಕೇಸ್ ಹಾಕಿದ್ರಲ್ಲ ಯಾಕೆ ಹಾಕಿದ್ರು
ಗೊತ್ತಿಲ್ಲ ಸರ್ ಸರ್
ಅಲ್ಲ ಒಂದಿನ ಸ್ಕೂಲ್ಗೆ ಹೋಗ್ಲಿಲ್ಲ ಅಂತೆ ಮಗು ಅಲ್ಲಿಂದ ಫೋನ್ ಬಂತಂತೆ ಸ್ಕೂಲಿಂದ ಒಂದು ವಾರ ಹೋಗಿಲ್ಲಂತೆ ಅದಕ್ಕೆ ತಾಯಿ ಏನೋ ಹಾಕಿದಾರಂತೆ ತಾಯಿ ಇವರು ಒಟ್ಟಿಗೆ ಇದ್ದಾರಂತೆ ಗಿರಿಜಾ ಅಂಡ್ ಪೆಟಿಷನರ್ ಸ್ಟೇಯಿಂಗ್ ಟುಗೆದರ್
Staying together.
ಒಟ್ಟಿಗೆ ಇದ್ದೀರಾ ಎಲ್ಲಿಗ ಗಿರಿಜಾ
ಕೆಲ್ಸ ಹೋಗಿದೆ
ಕೆಲ್ಸ ಸ್ಟ್ರೇಂಜ್ ಇಟ್ ಅಪಿಯರ್ಸ್ ಬಟ್ ಟ್ರೂ
The petitioner as well as the minor child are present before us in the court voluntarily. The petitioner has been duly identified by his Aadhaar card. We have also interacted with the minor child. It says that she is staying at home with the petitioner as well as her mother. And that she's not under any detention of any sort. It is stated that she is also going to school. The above factual situation, we are of the opinion that no further orders are required to be passed in this petition. The petition is accordingly passed. This is the number.
Let's say appear for the petitioners.
Yes. Yes, what is this?
My lords, in this matter, my lords, the petitioner is the husband, my lords.
Hmm.
My lords, what happens is, my lords, the petitioner's wife, my lords, is suffering from certain mental disorder, my lords. She was admitted in the hospital, my lords. Several cases have been filed from 2014, my lords, wherein she has absconded from the house, my lords. My lords, in this,
Also made an allegation of physical violence as against you.
my lords, it cannot be so, my lords. If I may point out, my lords, there's a
Why cannot
charge sheet.
it be so?
My
It
lords,
appears that those are the facts.
my lords, initially she tells the police that there is a physical abuse, my lords, which occurs, my lords. But after the police investigated, my lords,
Known of from 2023 onwards,
my lords, she not known.
you know who would be the first suspect?
My lords, my lords, initially what happens is, my lords, in the previous writ petition which was filed, my lords, they say that she had eloped with one Mr. Keethavanam, my lords, who was the detainee at that point, my lords.
Where is that said?
My lords, it's available at the order, my lords,
Hmm.
as well as the writ petition, my lords, which is available at page number 95.
When is that? Date, please.
My lords, that was in the year 2023, my lords, initially when I filed a writ of habeas corpus, my lords. It's mentioned that it is about at para 15 of the writ petition that the petitioner's wife was missing and he had complained with Orugam police station that his wife had eloped twice with a person by name Keetavanan, my lords.
This was your allegation,
My lords, this was the,
your case.
my lords, the
The
case was,
status report filed by the state government is stated as follows. Three is missing, so and so, one and so on.
it was one of the avowment, my lords, wherein previously she had eloped, my lords.
Srimati Nagamani submitted that whereabouts of the petitioner's wife are not known. Admittedly, missing complaint was lodged in FIR so and so. Keeping in view history of the and as extracted, this petition is closed, reserving liberty to the petitioner to file a fresh petition if it arises based on the result of investigation in FIR. So what happened in the FIR?
My lords, the FIR has not been investigated, my lords. It is kept pending, my lords, ever since 2023, my lords. There are no attempts made to trace out the wife, my lords. My lords, our avowment is, my lords, that she was detained by Viveknagar police station, my lords, at that point. Both the petitioner and the wife were detained, my lords. During the course of investigation, my lords, the wife was let go, my lords. Thereafter, the petitioner was detained in the police station, my lords. After the police released the petitioner, he visits the house to find the wife was not available at the house, my lords. That is when the missing complaint came to be lodged by the Viveknagar police station, my lords. My lords, if I may point out, my lords, at page number 49, my lords. In earlier situation, my lords, an FIR came to be filed, my lords, which came to be converted and charge sheet has been filed in that, my lords. Wherein the petitioner's wife gives a statement, my lords. It's available in the last paragraph at page 49. On 3rd of August 2022, around 10 in the morning, Keethavanan's wife, Sumitra, and her relatives came and informed me that my husband, Suresh Babu, has filed a complaint against Keethavanan and his family members at the police station. They took us both in the car and brought us to the police station on this day. Keethavanan made me believe that he loved me, will marry me, and took me forcefully, my lords. This is the statement given by the petitioner's wife, my lords. Thereafter, what has happened is, my lords.
This was on? When was this statement recorded?
This was
4th
on
August
4th of August 2022, my lords. Thereafter, what happens is, my lord, this said Keethavanan commit suicide, my lords.
Yes.
Please file a
We will.
what has happened in the earlier FIR also.
Please. My lords, a short date, my lord, since it's coming up for the second time. My lords.
After 2023, you come up only now.
Please. She's not a minor.
But
Please.
Two weeks.
Yes.
2 weeks,
Yes,
please.
Yes.
Great.
For the petition, my lord, I seek for a passover, my lord. Senior is saying it in the-
You said there is some kind of extreme urgency in the matter?
Yes, my lord, so. My lord, in this matter, writ petition was dismissed on twelfth November 2024, my lord. This is a matter where KADB has issued 28-1 notification, my lord. Before that only, my land got converted for industrial purpose, my lord. My lord, the identical matter was my lord, my lord,
Yes, list for the regular court. Termination set aside
Yes.
by the labor court.
Yes.
Challenged in writ petition by the employer,
Yes.
and the writ petition is allowed. Yes, what is the,
Lord, the first appellant's husband was a driver, my lord. Lord, on the charge of unauthorized absent, my lord, he was removed from survey.
when is the unauthorized absence from?
My lord, from intermittent, my lord, from 11/12/2000 onwards,
11/12?
2011 onwards. In fact, my lord, he has produced some document, medical documents, which shows that my lord, he was not, he was prevented for attending his duties, my lord. Then, my lord, annexed C is the document, page 46, my lord, medical document he has produced. The learned single judge, my lord, merely because date is not mentioned in the medical certificate, my lord, page 46.
Yes, date is not mentioned in the medical certificate.
Yes, my lord. It is for the doctor, my lord.
Hmm.
It is the. In fact, my lord, after recovering from ill health, my lord, he is seeking permission to report for duty. As per annexure, page 50, my lord, one of the reply he has given.
It was on account of this illness that he passed away?
Yes,
When did the employee pass away?
passed away on,
Sorry?
yes, on 22/2/2000, 28/5/2015.
28/5.
2015, after, during the pendency of the dispute. He was
To
removed.
apply for leave.
My lord,
Did he apply for leave?
my lord, in fact, my lord, annexure, he had sent a medical document.
Medical document will not do,
Yes.
counsel. You have to apply for leave. Have you applied?
Yes, my lord,
Where is that?
I have not produced, my lord.
Oh.
In
Then-
fact, my lord, after recovering from ill health, my lord, he is seeking for reporting for duty.
That will not do. That makes it unauthorized absence.
Yes,
You have to make an application for
Yes.
leave along with the medical certificate.
Yes.
Did you do that?
I have not. produced.
Admittedly not. Now, tell us what happened in the inquiry. Which is the inquiry report?
Inquiry, my lord, inquiry report, I have not produced, my lord. Labor court held that, my lord, domestic inquiry is not fair and proper.
Is this? Where is the inquiry report, counsel? That is what we are expected to consider now.
I will produce. Before the
Yes.
labor court, my lord, all documents are available.
Will that do?
Please.
You're asking us to decide on the correctness of a finding.
Yes.
So at least the minimum documents we must have.
Please, please.
What is the finding of the labor code?
Labor court, my lord, held that, my lord, domestic inquiry is not fair and proper.
Why?
That's,
What is the finding? Please tell us. Minor punishments of he was asked to improve his performance. First party failed to improve. Thereafter, inquiry is held. Based on inquiry, is dismissed from service. Work contract is a case of deceased first party that in the year 2004, he was discharging duties on the road. Hassan Bangalore, he met with an accident, resulting from which grievous injury to his entire body, underwent operation of abdomen. Jayanagar General Hospital. M11 medical certificate by Civil Surgeon Jayanagar. Second party is issued notice after the sitting. The said show cause notice. Also the history sheet of the first party. What was the, which is the memo of charges? What is the charge against you? Only unauthorized absence.
yes,
Where is the charge?
my lord, in the order of dismissal itself, my lord, it has been mentioned.
Where is it?
Page annexure G, my lord, page translated portion at page.
Annexure B is the charge.
Charge memo.
Because he was a trainee employee, my lord, show cause notice was issued. Annexure B, my lord. The translated portion is at page 44, my lord.
You're unauthorizedly absent
Because-
from training with effect from 11/12/2011 without applying leave. As such, depot manager submitted report as per your. One of the schedules in the depot were cancelled. It is very difficult to operate schedule as such. You're responsible for inconvenience. For your negligent act, you're ineligible to continue as trainee. When was he appointed? Why is he continuing as trainee for so long? The
9 years.
labor code says that he's
My lord,
continuing as
there
trainee for
appears to
9
be
years.
some, my lord, mistake by the corporation, my lord, on this factor. Bringing him on probation, my lord.
He continued
to-
on probation for 9 years.
My lord, it appears, my lord, he was transferred from place to place. So during this period, my lord, he was not brought on.
He actually did undergo
Could
a
have been, yes, my lord.
he
He was
underwent
entitled to be, my lord.
accident also.
Yes, my lord, no. If your lordship could see, my lord, the reply, my lord, kindly see annexure E, my lord. E reply, my lord.
That is not his case.
That's not his case at all. My lord. Annexure E, my lord, page 53.
In fact, my lord, in the
C.Y.
said
Krishna.
reply, my lord, yes,
Please.
please.
Page 53, my lord. Shri C.Y. Krishna joined on 7/7/2003 as a trainee driver and discharging my duty as a trainee driver till date since from 9 years. I've been working for rupees 3040, but unfortunately, my mother who have birth to me died on 1/7/2009. This will be seriously affected to me. Further, my wife, so-and-so Kantama, also died on 12/8/2010. And for the aforesaid depression, I developed giddiness, and when I was discharging my duty, for which I took treatment at Jayanagar General Hospital as an outpatient and living in my house without disturbing anybody. As such, I'm healthy and I'm requesting you. This is his reply. And that too, my lord, when he
10/4/2013.
my lord,
10/4/2013.
yes, my lord, till my lord, a period of absence, my lord, is from my lord
11/12/2011 onwards.
11 till my lord 2013. It's a long period, my lord. And added to that, my lord, he has a past history, my lord. He's a
Past history, unless that is why we asked you what is the charge sheet.
my lord, the charges,
If
my
the
lord,
charge memo is not with regard to the past history, you cannot rely on the past history to
my lord,
inflict a punishment on you.
in fact, my regulations, my lord, says so. Regulation 25 of the
Regulation-
KSRTC regulation
What does
says,
it
my
say?
lord, that one of the circumstances that can be taken into consideration by the disciplinary authority at the time of imposing punishment,
It's
my lord.
only at the time of imposing punishment.
Punishment, my lord. This
It
is
cannot
what,
be, it
this is
cannot
what
be
I have done,
taken,
my,
it cannot be taken into account by the inquiry officer.
no, inquiry officer has not taken.
Inquiry officer has taken.
My lord, no. Inquiry officer has not taken into consideration.
Where is the inquiry report?
My lord, report is not produced, my lord, because the,
If
the domestic
inquiry
inquiry
report is based on anything but the charge.
my lord, the domestic
Goes.
inquiry, my lord, is, no, my lord, the
It's a
domestic.
finding of the labor
Lord,
court.
can I just pass on, my lord? It's in Kannada, my lord. Thing, my lord could. There's not even a line, my lord, as regard to his past history, my lord. Not even a single line, my lord, on, my lord, what happens is, my lord, after the report is my lord, otherwise I get prejudiced, my lord. First is I have to prove the charge. Then
Correct.
while imposing punishment, my lord, I'll look into his past conduct, and if he has no past conduct, my lord, the disciplinary authority would take a lenient view, my lord. That is how the procedure is being followed, my lord, in corporation. My lord, in corporation, it's, the workforce is 1,70,000, my lord, of which 70% comprises of the crew members. And if they don't appear, my lord, if they don't absent themselves, my lord, it becomes difficult to operate the schedules. And he has been given, my lord, the minor punishments on 9 occasions, my lord. If your lordship could see in the order of dismissal, my lord, there is a reference, which is at page 63, my lord. Not even a single line. If your lordship could have a look at 63, my lord, page 63. There is a reference, my lord, by the disciplinary authority as regard to his absence, my lord. And only he chose to bring this medical certificate when he chose to come to the corporation, my lord. That was in 2013. My lord, the leave rule says, my lord, that he is to apply for leave. He has not even applied for leave, my lord. Therefore, it becomes unauthorized. For the labor code to hold that it is not unauthorized, my lord, and charge is not proved, my lord, is erroneous. And he says his wife died, but his wife has given evidence, my lord. Maybe he has married second time.
First wife.
Maybe.
wife.
He says he was in depression. Page 84, my lord, in page 84. Annexure M, my lord.
Some the state is different. Meenakshi is the wife. Antarma was the wife who died.
My case is, my lord, the question of reinstatement did not arise at all.
Not the question of reinstatement, but of back wages.
Back wages.
The labor code proceeds, my lord, that I could not have dismissed him from service, gives him all relief, my lord, reinstatement with full back wages.
If the corporation,
Some lump sum payment to the, because there appears to be some amounts that he's entitled to.
My lord,
This workman is entitled for benefits, whatever he was entitled till date of removal.
my lord, till the date of dismissal, my lord, we would pay, my lord. Till the date of his date.
That has already been
whatever he is entitled to, my lord.
Yes.
If it is not paid, we'll have it paid, my lord. Usually, my lord, in the corporation, till the date of dismissal, it is paid. My lord.
Lord,
If
instead
we have
of
put in, my lord, a requisite number of years of service, my lord. But here in this case, I
Lord.
think probably, my lord, your lordship will have to, my lord, your lordship will
Instead
have to
of-
hold, my lord, which I will not oppose. Because for 9 years, my lord, I submitted to your lordship because I have something on record, my lord, that there is some mistake on the part of the corporation in not bringing him on probation.
not only for 9 years, till the date of removal. When is the date of removal?
My lord,
2000. 3/5/2013.
3/5/2013, my lord.
So till then,
My lord, it's not that, my lord, for 2 years he'll be a trainee, my lord, for 2 years probation. For in case, my lord, if he has any cases, my lord, it will be postponed. So so what they say is for about 4 years, my lord, he should have been.
meanwhile, instead of all this,
Yes,
why don't you agree on an amount so that we can close it on that account?
Lord,
If both of you
instead
will
of-
agree for an amount.
Instead of paying back wages, my lord, one of the legal representative maybe provide an appointment on compassion.
That we cannot, I'm sorry. That is not, all that is not something, this is only because he
I'll find
was
out, madam.
continued for 9 years
My lord,
without his probation having been declared at all. Therefore, if you can agree on an amount, please.
yes, I'll find
And
out, my lord.
if you're arguing on the merits, this kind of half-baked arguments, we cannot hear. Yes. Please make an attempt.
Please.
So I'll inform him,
Weeks.
my lord, whatever the decision taken.
Next week,
Please.
please.
My lord. Yes, my lord. My lord, I'll definitely, I'll assure the court, my lord. I will not go back on my lord, I'll do something, my lord, see that the matter is settled.
List after 2 weeks.
2 weeks, my
In
lord.
the meanwhile, the parties will attempt a settlement of the dispute amicably. Give it.
Please, serial number 9, sorry. 28 one is surrendered. But keeping in mind, my lord, the industry is being set up, collected matter, my lord, using it as fast and intermodal, and seeking similar in. Because my lord, industry is already being set up. Same notification, same notification, same date, industry is already being set up. Keeping that in mind, there's an intermodal granted.
To take any consultative action. Yes. Learned counsel for the appellant submits that with regard to an identical matter, that is writ appeal number 1846 of 2024. The regular bench has already passed orders directing the respondents not to take any precipitative action. It is submitted that the facts of this case are identical and that the dismissal of the writ petition filed by the petitioners challenging the acquisition was also on the same grounds. These submissions are recorded in the light of the order dated 16/1/2025 passed by the regular bench of this court, hearing the matter in writ appeal number 1846 of 2024. The respondents are directed not to take any precipitative action in this matter as well, list along with writ appeal number 1846.
See, he is not told. Not only billing notifications are charged. Say, if same notification is taken, then that's.
Yes.
For the,
Dismissal,
this my lord,
the manager in charge.
no, this is
Oh, I'm sorry.
institution, my lord, institution.
this is
Yes,
ESI.
ESI, but yes.
What is a question of law?
Question
Only
of law,
questions
it
of
is
fact.
not raised in the petition, my lord. They have demanded with effect from
the respondent.
March 2011. March 2011, as per section 45A, my lord, they can't demand beyond 5 years, my lord. Unfortunately, it is not raised in the petition. Section 45A provision, my lord, section 45A, my lord. Provided for the no
Yes,
such
sir.
order shall be passed by the corporation in respect of period beyond 5 years. They demanded with effect from March 2011. Order is passed on 1/8/2018, my lord. Order is passed on 1/8/2008.
This is SFC. ESI Act. Please read.
Yes, I will read provision, my lord. Provided further that no such order shall be passed by the corporation in respect of the period beyond 5 years from the date on which the contribution shall be become fine, payable. Demand assessor officer passed an order on 1/8/2018 directed to pay the amount from March 2011. man. Order dated 1/8/2018. man. Prior to 45A, my lord.
Respect of a factory or establishment, no returns particular registered or something furnished in accordance with provisions. Number of principal of immediate employment, says in the sentence. The corporation may, on the basis of information available to it, by order determine the amount of contributions payable in respect of the employees of that factory or establishment. Provided that
provision.
no such order shall be passed by the corporation
Yes.
unless the principal or immediate employer or the
Period
person in
beyond-
charge has been given reasonable opportunity. Provided further that no such order shall be passed by the corporation
In respect of the period
beyond 5 years
from the date on which the contribution shall become payable. I think order is there, my lord.
There is such a contention.
That is unfortunate. It's a question of law, my lord, this.
It's not law has to be
Is
raised
raised when it
in
was
an appeal.
raised. After filing,
Frame the question of law ourselves, can we? Can we frame the question of law ourselves?
yes,
Or is it required to be
yes, and
raised by you?
82 my lord, before the High Court, my lord, I can, my lord, 82
You
two,
can-
my lord.
Should it
Only
not
on the
be
question of
raised?
law, my lord, it can be.
Should it not be raised? Or is it for the court to frame the question of law and admit?
This law says, my lord, they can't demand.
No
but
appeal shall,
This,
that is not the question we are asking
Yes.
you, Counsel. An appeal shall lie to the High Court from
Court.
an order if it involves a substantial question of
question of
law.
law.
The appeal should involve a substantial question of
Question.
law. It must be raised by you. We cannot raise it.
Permit to raise, my lord, by additional.
Yes, do the needful, whatever.
Yes,
Please raise it.
Yes.
Unless it is raised,
yes, please.
we cannot
Yes.
admit
Yes.
unless the
Yeah,
question of law is raised by you. It has to arise.
Sorry, my lord.
For it to arise, it must raise, somebody must raise it.
Yes.
Yes,
It hurriedly filed, my lord, I could.
you must raise a ground. You must also raise a
Yes,
substantial
sure,
question of
yeah,
law
please.
on which we can.
Yes, please.
We probably may be able to mold the question of
Yes,
law.
law.
We cannot raise it. Yes, learned counsel seeks 2 weeks.
Please.
Weeks. Counsel for the appellant seeks 2 weeks time. For. Yes, this is the matter. Dismissal of manager in charge. In charge
The-
manager of third correspondent society, audit in 2000.
section. Dispute raised by the appellant under section 70 of the Cooperative Societies Act was answered in favor of the appellant, holding that the termination is bad. Then, my lord, the appeal filed by the employer, that is the bank, my lord, that was also rejected. Of course, a very considered order by the appellate authority. But the learned single judge, my lord, mostly only, my lord, he proceeds on the footing that there is a confession letter by the appellant here. Therefore, my lord, that has not been properly considered. Of course, my lord, the learned single judge did not look into what exactly traversed before the registrar, where my lord, this issue was also considered, but not to the fullest extent. I would definitely accept that. But there, my lord, mostly the proceeded on the footing joint registrar that there is no proper opportunity given to the employee. Therefore, inquiry is not fair and proper. Even otherwise, in that particular paragraph, the Honorable Registrar said, my lord, this confession letter, so-called confession letter, has no value for the reason, my lord, subsequently, one Mahesh, my lord, one or 11, that I don't remember the name, my lord, he has given a clear letter stating that, my lord, this employee has not given any confession letter voluntarily. It was obtained at his residence by the bank officials to save their skin. All that, my lord, finally the authorities said that termination is bad. That order came to be challenged before the appellate authority, that is the Karnataka Appellate Tribunal. Appellate authority, my lord, very.
Just a moment. When
Yes.
was the confession?
My lord, 31/12/2001.
When was the charge sheet?
Yes, my lord. The charge sheet, Lordship gets it, my lord, the charge sheet is, those are the 2 dates. That is, my lord, charge sheet is 18th March 2002.
No, first notice was on 18th March 2002. You submitted your reply on 23/3/2002.
My reply is 23rd March 2002.
Articles of charge issued on 14/5/2002.
Here, my lord, the showcase notice is 18/3/2002.
Yes, the articles of charge is 14/5/2002.
Yes.
What were the articles of charge?
Articles of charge, my lord, I'll come to that. There's little bit of confusion with regard to, my lord, the dates.
I thought, in fact, I should have given a better synopsis, giving the,
What you say in your.
to avoid all
synopsis,
these confusion.
What exactly is, were the articles of charge?
Articles of charges, I'll come to that. Articles of charges 14/9/2002.
15.5, yes.
Yes,
What does it say?
14/9/2002.
The charge.
There are, in all 8 charges.
Hmm.
I'll just,
Where do we get it?
yeah, that's exactly. Karana Kedava notice, Lordship Annexure C, my lord, 118. That is in Kannada.
CH-3 is the.
118.
Show cause notice, 18.3.
18/3 is Shokas notice. In fact, charge sheet as such, my lord, it's not produced by the
Is the
petitioner.
inquiry.
But
report
it is in 18/3/2002 Annexure C, my lord, whatever the charges that were leveled against me has been reproduced. That your lordship gets it. Not, I will not trouble your lordship the typed copy. May I request your lordship to kindly turn to 127, page 127.
Okay, so what is your reply to this?
My lord, my reply is I have denied the charges.
Where?
Entire. Next
Where?
page, my lord. Next page, 130, Annexure D. There, my lord, may I request your lordship to kindly turn to the translated this thing, my lord.
Yes.
141, my lord. 141.
41, yes.
In connection to the above cited subject, I, Mahesh, so and so, my explanation as follows with regard to the misappropriation of funds for the period between 2000 and 2001 at Halebeedu so and so bank. The allegation of misappropriation of funds during the tenure of my service as in charge as is far away from truth. I submit that I have not misappropriated any funds during my tenure as manager in charge. Then, my lord, with regard to each charge, my lord, he says how that amount has been deducted and all that.
Denied the charges.
Yes, total denial.
In spite of the confession on 31/1/2001, he denies charges.
Denies the charge.
Now, is the confession of 31/1/2001 proved in the inquiry?
It was.
It was proved in the inquiry?
No, it is not proved in the inquiry. It's not proved in the inquiry.
Not produced?
Yes, they did not produce it.
Where is the inquiry report, please?
My lord, the report of the inquiry officer. Unfortunately, my lord, in the writ petition, my lord, they did not chronologically file all those documents. Except, my lord, Annexure F is again a Shokas notice. Instead of troubling your lordships with all those dates and all that, may I request your lordship, 1 minute, my lord, it is up to your lordships.
That we can, I'm okay.
Those 4 or 5 relevant documents only, I'll place it. With regard to, my lord, the charge sheet, my reply, the 31/12/2001 so-called confession letter, the another exhibit M11 for which I have relied upon, for which, my lord, the registrar has relied upon, for which, my lord, the appellate authority has also relied upon, those 5 documents. Then, my lord, the dismissal order is a very slipshod order. I don't want to trouble you, lordship, with all that, even though I have a case on that point.
Only this was the confession.
Yes, my lord, I follow.
Was it proved in the inquiry?
Yes.
If it is not proved in the inquiry, then whether it can be relied on to.
I follow. That's a short point.
Proved, according to you,
M34.
in the inquiry. And what is the finding in the inquiry with regard to that?
Inquiry findings is not forthcoming. But it's not the report.
In the inquiry, whether it is properly proved, what is the finding in the inquiry on the confession? Unless it is proved in the inquiry, you cannot rely on it.
That's why, my lord, the documents were called for. Even then, I have those documents. Only relevant to those 6 or 7 documents, I will place it in a chronological order to avoid, my lord, any inconvenience to the court. That
Yes.
is better, my lord. Otherwise, why
Provide
should
it
we
as
trouble
a
your lordship?
synopsis and give the copy to the other side also.
Yes, sir.
Please provide it as a synopsis.
Yes,
When
I'll
do
do that, my lord. I'll do that.
When do you want it?
Can be taken up on 17th, my lord, because of translation and all that. Only those 6 relevant documents I'll produce. Very well.
18.
No,
Yeah. Yes.
18th.
Yes. At the request of the learned counsel appearing on either side, matters adjourned to 18th of this month for final hearing in the matter. It can be heard on that day. Yes.
one submission, my lord. My lord, last week, my lord, management settled nearly 20 to 30 matters, my lord, before honorable single judge. My lord, on trainee, all trainee matters, my lord, reinstated, my lord. If my learner friend is look into this matter, my lord, I am. Bedasam, no, Lok Adalat Bedasam. ಇಲ್ಲ ಸಮ್ ದಯವಿಟ್ಟು ಇಲ್ಲೇ ಬರ್ಲಿ ಸಮ್ ಕೋರ್ಟ್ ಮುಂದೆ ಬರ್ಲಿ ಅಲ್ಲ ಮೆಮೊ ಹಾಕ್ತಾರೆ ಎಲ್ಲ ಜಾಯಿಂಟ್ ಮೆಮೊ ಹಾಕಿದ್ದೀವಿ ಸ್ವಾಮಿ ಕೋರ್ಟ್ ಮುಂದೆ ಅಲ್ಲಿ 30 matters are settled by way of filing joint memo, my lord. My lord,
Try to understand how difficult it is. He will not be able to convince in this case to the law officers. So he can tell that court has.
My lord, in similar matters, my lord, they file memo before the honorable single judge, my lord, settled, my lord. That's, yeah.
Listed before the Adalat. That's listed before the Adalat. What she says appears to be reasonable. Otherwise, there is a chance that it will be settled if we list it before the Adalat. You can do the pre-Adalat conciliation can go on. This March 8th, we have an Adalat coming up.
Before that pre-Lok Adalat
Can be, that can be done. We have a Adalat coming up on the 8th of March, nationwide. Why not? Yes, heard both sides. It is submitted by the Learned Counsel for the appellant that if the matter is placed before the Adalat, there is a chance of settlement in the issue. List this matter to be considered before the Lok Adalat to be held on 8th March 2025. So all pre-Adalat conciliations can go on. You've complied. Non-compliance without objection. 1990.
The competent authority, my lords, under the provisions of the KPADFE Act is before your lordships. The question of law, my lords, person of high political eminence who has the capacity to influence in terms of financial decisions has stood with the respondent number 2 and 3 in various functions. There is, my lords, indeed a close financial relationship between the respondent number 1 before this honorable court and 2 and 3. So, my lords, the 5-2 petition was filed seeking the making of properties identity attachment absolute. The honorable special court only the technical interpretation that he is not a promoter. My lords, there is no dispute to the fact that there is indeed been some sort, my lords, of a financial transaction between the two and there being some sort, my lords, of understanding. But on a hyper-technical, lord, appreciation that he does not come within the bracket of promoter of the company, and also he cannot be held to be a person of.
Yes, the act. What is the Requirement of the provision,
My lords, section
it must
3
be a person.
of, my lords. Amongst very many other things, my lords, I will take my lords to section 3 clause 2, my lord.
Not a person connected to, etc. It must be a person of.
Of, please, my lord, section 3 to requirement, my lord. My lord, permit me to refer to my lord, section 3, paragraph 2, right above paragraph number 3, please, my lord. Clause number 3, my lords. It starts with the government may in order to, my lords. Above paragraph, clause 3, section 3, my lords, clause 3. Read to the last part of section 3, clause 2, please.
Hmm.
The government may, my lords. I'm able to point out, my lord. I'm repeating section 3,
Yes.
clause 2, my lords.
3 clause 2. Yes, yes.
Please, my lord.
Hmm.
It starts with the government may, my lords. The government, in order to protect the interests of the depositors of such financial establishments after recording reasons in writing, issue an order by publishing it in the official gazette, attaching the money or property believed to have been acquired by such financial establishment, even its own name, or in the name of any other person from and out of the deposits collected by the financial establishment. And next part will be important, my lords. And where it transpires that such money or other property is not available for attachment or not sufficient for the repayment of the deposits, such other property of the said finance establishments or the personal assets of the promoters, partners, directors, managers, or members, or any other person of the said financial establishment.
Promoters, partners, directors, managers, or members.
We are not
Or
concerned with those,
any other
or
person.
any other person of the said financial establishment.
Yes, what is the connection that you have shown?
Please, Lord. My lords, may kindly take my lords, give you the order, my lord.
Yes.
My lords, may kindly take page number 28, my lord. My contention is recorded, my lord.
28.
Please, my lord. Page number 28 of the compilation, please. Para 11 clause B, my lords.
Yes, yes.
It is further submission. My contention has been recorded, my lord.
Yes.
Further submission that in the notification, it is alleged that the respondent number 1 had played a role of clandestine promoter and beneficiary of the IMA group by investing in the form of sweet equity rather than being a formal promoter who invests equity in the form of money. But this is my entire premise of submission. And my lords, the honorable court, my lords, may can you take page number 33, my lord?
Documents to that. Link between.
My lords has recorded, my lords. In fact, documents may be called for, but I only pursue your lordships too.
I think CBI has to take it.
How's.
And
In fact,
ED also has done.
my lords,
ED also has.
because the CBI has filed a charge sheet, my lords, linking the money trail of the financial establishment, my lords, to the respondent number 1 before this honorable court. And in fact, my lords, at para I in page number 33, my lords, there have been business transactions. I'll be able to point out from the findings, but only on a hyper-technical argument that he's not a person of, my lord. I'll pursue your lordships on the definition of. Page number 33, my lords, clause I. The respondent number 1 and his wife are running Mr. So-and-so, and the said private limited was publishing the CH-3 daily Urdu newspaper. The said Danish publication private limited maintained current account with Mr. Jammu and Kashmir Bank in the name of CH-3 daily. The business of the said CH-3 daily newspaper was transferred to Messrs. IMA Publications Private Limited, which is the financial establishment. Clause J, my lords, may kindly see, my lord. The respondent number 1 had given a standing instruction to Mr. Jammu and Kashmir Bank to transfer the amount to Messrs. IMA Publication Private Limited from the account of CH-3 daily newspaper. And in this regard, the petitioner has produced the letter given by the respondent number 1 to the said bank as per Exhibit P2. But there's a standing instruction that as and when there is a requirement, money should be transferred from the account of the respondent number 1's firm to that, my lords, of the financial establishment. My lords, can you take page number 34, please, my lord? Sorry, page 34, paragraph 13, my lord. With the above undisputed facts, the contentions of the competent authority and the respondent one are analyzed. It is clear from the attachment notification that the government, after considering the report of the special officer and competent authority of the IMA,
the petitioner, and the charge sheet submitted by the CBI has come to the conclusion that the respondent number 1 has played a key role in utilizing his public office and goodwill to promote the business activities of the IMA group, as well as in return getting the financial benefits in the group, and thereby had played a role clandestinely as a promoter and the beneficiary of the IMA group by investing in the form of a sweet equity rather than being a formal promoter who invest equity in the form of money, and hence the government was pleased to attach the scheduled property.
Yes.
Clause at page number 42, my lords. In fact, my lords, in the Consumer Protection Act, no, my lords, there's a section which casts a lot of responsibility, liability on influencers or endorsers. But an endorser has been defined under the Consumer Protection Act as any person who has the ability to influence the other person to decide his financial pattern of behavior. But here is a person who has been, my lord, who is at the right point of time a representative of the people. But he is sharing the dais, he making it public that my account and the account of the financial establishment are a sister concern sort of in legal relationship, because there has been a standing direction to the bank to transfer the money from the account of the respondent number 1 to that of the financial establishment as and when it's required. Because the Honorable Court, my lords, may kindly take panel number 21, my lords. There's no dispute to the fact that there is indeed some relationship between, my lords, the respondent number 1 and the financial establishment. In the light of the above definition, 21, my lords, page number 39, foot of the page. In the light of the above definition of the term promoter, the facts of the present case are analyzed. It is not the case of the petitioner that the name of the respondent is shown in the prospectus or is identified by the company in its annual return referred to in section 92, as the respondent number 1 has control over the affairs of the company directly or indirectly as shareholder, director, otherwise. Therefore, line number 3, madam. Therefore, the respondent number 1 can't be treated as a promoter of the respondent number 2. No doubt, my lords, may kindly emphasize this. No doubt, the materials placed before this court reveal that the respondent number 1 had played some role with the business of the respondent number 2 and had a business relationship with the respondent number 2 and 3. It is clear from exhibit P1 and P2 and evidence of RW1 that the respondent number 1 and his wife were running CH-3 Urdu daily newspaper and so, which belongs to them, and the said CH-3 newspaper was given to IMA Publications Private Limited. Further, as deposed by RW1, the advertisements relating to IMA jewelers were published in the said newspaper. Para 22. The contents of P1 and P2A reveals that the respondent number 1 had instructed his banker to transfer the amount from the account of CH daily to the account of Mr. So. Mr. Publishers Private Limited is the partner publishing company of the said CH Daily Bangalore. My lords, may kindly emphasize this. They are partners. The Honorable Court recognizes, acknowledges, and accepts it, my lord. Further, Exhibit P7, the account statement relating to the account of CH Daily reveals, Exhibit P7, that even after November 2017, the amount was credited to the said CSS account from IMA entities, particularly on 21/11/2018. So it's the accepted fact that the monies from the account of the financial establishment were indeed credited to the account, my lord, of the firm that was being run by the respondent number 1 here in my lord. Therefore, it is clear there is a business relationship between the respondent number 1 and the 2. But on the basis of said such business relationship, it can't be said that the respondent number 1 has played the role clandestinely as the promoter of the respondent number 2. I stop here for a while, my lord, permission, my lord. But the Honorable Special Court has evaluated the definition of promoter with reference to that of the Companies Act. Lord, the purpose, the aim, the objective of the two enactments are absolutely different. But here, invoking the principle of adjustive generis, Lord, promoter, manager, partner, director, or any other person of the financial establishment will have to be interpreted so as to any other person of. Because I ask myself, why would the legislature in its wisdom choose to use such a highly flexible and elastic word of minutes? It is only because any person, the legislature in the wisdom wanted to include any person who has any degree of relationship with the financial establishment in order to make the establishment, my lords, collect some money, my lords, would come within the blanket of, my lords, of.
Would an employee come within that?
Paid employee indeed, please. My lord, in fact, my lords. If my lord could kindly take para 24, my lord, page number 42, my lord. Good. Sixth line from the foot of para 24, my lord. No doubt. No doubt, the presence of the respondent number 1 being the MLA and the minister with the respondent number 3 in various platforms, it should have been platforms, my lord, and having business relationship with IMA publications that might have boosted the confidence of the people with respondent number 2 and 3. But on that basis, it cannot be held that the respondent number 1 had acted as a promoter. It is not my case at all, my lord, that the respondent number 1 has acted in the capacity of a promoter. My submission has always been that he has clandestinely promoted the business of the financial establishment, induced and influenced the depositors to invest the money in a belief that the influencer himself is convinced that, my lord, there is a profit that they can get. In fact, my lord, kindly take page number 20, about 25, my lord. As contained in the petition, the act of the respondent number 1 might have created lending credence to the depositors. And the respondent number 1 had assisted the respondent number 3 with the affairs of the respondent number 2. And the conduct of the respondent number 1 might have promoted the business of respondent number 2, but on that account, which one in this? So there's absolutely no dispute that respondent number 1 has indeed promoted, but on a hyper-technical definition that he's not a promoter. My lords, may kindly see, my lords, the definition of off as can be seen from various, my lords, dictionaries, my lord. My lords, may kindly permit me to refer, my lords, to 3 definitions. One, my lords, is of Black's Law Dictionary. I'll make a note, my lords, or I'll take an extract of the definitions and I'll submit before the Honorable Court, my lord. Off, my lords, has been defined as associated with or connected with, usually in some casual relation. The word has been held equivalent to the after, at, or belonging to. My lords, the law lexicon of P. Ramanatha Iyer, my lords, 1992 difference says, owned by, belonging to, pertaining to, relating to, concerning. And my lords, in the concise Oxford English Dictionary, my lord, of will mean among, belonging, expressing the relationship, indicating an association between 2 entities, expressing the relationship between a general category and something belongs to such a category, indicating an association. So the Honorable Court, in my humble submission, my lord, having returned a finding, my lord, the finding which has not been challenged. Lord, I can understand, my lords, the respondent number 1 coming before this court and my lord submitting that the finding that I have a relationship, how much soever loose it may be with the financial establishment, is wrong. So that, my lords, the finding has attained finality. So now the only question, my lords, before your lordship would be, if a person has a certain degree of control or of influence and can be held to have promoted the business of the respondent number 2 and 3, as the Honorable Court says in para 25, could, my lord, such a person be held to be a person not coming into the bracket of section 3.2, only on a hyper-technical argument that he cannot be considered to be a promoter? But a sweet equity, my lords, though not used in the terms of KPID Act, has now come to say, wherever, my lords, a person, my lord, invests his time, resources, and influence, though not in terms of money, but if at all he invests, my lord, the sweet equity, he, my lord, would be, in my humble submission, a part and would be within the definition of the financial establishment.
We are not mistaken. It's not sweet equity, it's sweat equity.
I stand corrected, my lord. I stand corrected.
Sweat equity, because
Please,
something of his he is
Please. I stand corrected. I stand corrected.
utilized.
In fact, the Honorable Supreme Court, my lord, times and again, including, my lords, in the very famous or perhaps infamous Patanjali case, has held that every person who endorses has now to take up the responsibility of his own endorsement. Though, my lord, a similar provision, my lords, is not found in the KPID Act. But my humble submission is, my lord, when the court accepts that the mass appeal and fan following may have resulted in promoting, because the court could not have taken such a hyper-technical view, is my humble submission.
What is the interim prayer you're seeking?
Plus the properties that were attached, please, my lord. In terms of 3-2, but since 5-2 has been dismissed, my lord, the 3-2, my lord, would not be enforced. So I have, my lord, sought the leave of the honorable, I sought the order of the honorable court, my lords, to attach those properties, my lord.
Attach those of the properties which have not been, what happens between the order of the special court
My
and
lord, my order for status, I understand, the point is well taken, my lord. Even in order of status quo, my lords. In fact,
'23 order.
But may I seek my lord's indulgence, my lord. Now that my lords, your lordships have heard the matter, my lord, my learned senior friend, my lord, my learned senior friend appears for the respondent number 1. Because he's also not there, my lords. I will prepare a brief synopsis, my lord, of the judgments that I want to rely upon. But this is one of the biggest scams, my lord, that has hit this state. 65,000 depositors, 1,400 crores at stake, my lord, and only 88 crores has been paid. So almost about 2,600 crores, my lord, is what is due. And
Yes.
may I pay for, my lords, any short date so that, my lord, the matter still could be disposed of, my lords.
Yes, admit. So and so, council takes notice for the respondent. Call for the records. List on, give a short date.
May I pray
In
for
the meanwhile, status quo as on today with regard to the properties in question shall be maintained by the respondent till the next date of hearing.
regarding possession and transfer of title. So, my lord, status quo orders sometimes create more problems than, my lords, it would answer. So may I pray, my lord, that it could be in terms of possession and of conveyance, my lord.
With regard to the transfer of possession as well as title over the properties in question. Status quo with regard to possession and title of the property shall be maintained by the respondent till the next date. As on this day, already said. Yes.
Your Honor, sir, indicate the date, please, my lord. Deeply obliged.
In appeal for the petitioner's minutes, there is in fact a delay of
71 days.
But the urgency is this, minutes. The department is coming that they will issue the garnishi order. This is only on the point of damages, minutes. All the salary has been paid and the contribution has also been paid. Page number 297, there are some difficulty in paying on time, minutes. For that, damages has been imposed. And these were all during the COVID period. The petitioner is in the business of garments, minutes. During the COVID, there was no business. As they had the problem for payment of the salaries itself, so they couldn't pay the contribution on time.
What is the contribution period? 1 May 2019 to 2012, 2020.
Please, minutes. After 4 months, the COVID started in March. And the only question to be decided is this, minutes, whether the ESA corporation in fact has a discretion to waive off or to reduce the damages. Plus in the gratuity and PF, they don't have the discretion because it goes to the employee. In here, the contribution goes to the employee, but the interest and the damages goes to the miscellaneous fund. Hence, the employees will not be.
Contribution, your contention is already paid.
Already, they have also agreed that.
Belatedly, but paid.
Belatedly, but it has been paid.
Yes. Yes, the delay notice will have to go. Notice on the delay as well as in the main application.
Delay also.
Yes. Can take notice. So and so, learning council is requested to take notice on behalf of respondents, of the respondent. In the facts and circumstances of the case and in the light of the developments in IA 2 of 2025. There will be a stay of further proceedings in pursuance to the order under appeal till the next date of hearing.
What the order members, Annexure G is a demand notice which they have issued. That is what I have asked for the stay.
Pursuant to Annexure G. Further proceedings pursuant to Annexure G till the next date of hearing.
Please, great.
Please serve a copy on Geeta Devi.
Reading for appellant. My lord, the amended appeal memorandum is ready, my lord. I'll serve a copy to my learned.
Please
friend
serve a copy and
it in
file
the
it. Yes, it is submitted by learned counsel for the appellant that the amended copy of the appeal memorandum is being filed today with copies being served. List. There. That also you, okay,
Abhiman, it is.
yes.
I appear for the appellant in this case.
This is
Regard to
11.
11.
Item 11.
I appear for the appellant.
Hmm.
I may be permitted to amend the constitution right now in the court, and amended appeal will be filed in the office. It's with me, your lordship. I've served the copies to them. And with regard to the IA is concerned, your lordship, I am in the peaceful possession, rightful owner of the property from 1972. My husband, I am the deceased of the appellant, widow. My husband was carrying on the watch repairing shop from 1972 to till he died. Till he died in, he died in 30th of June 2017. From 1972 to 30th June 2017, my husband was carrying on the, I produced the statement of objections and with the license, all the documents to show that my husband was carrying on the business. After his demise, I have taken the license to pack up the noodles in the premises. I have taken the license. They're not letting me do my business. They collapsed with my wall. I contending that it's kindly peruse my statement of objections and the
Have
court
to be heard on merits.
photograph, your lordship, that they are not letting me do my business. They have they have filed an IA stating that I am putting up the construction. Kindly for a moment peruse the photograph, your lordship. It's a dilapidated condition. They themselves says in the affidavit, it's more than 50 years of old construction. During Madkar, your lordship knows very well because of rain, wall get collapsed. I was under the impression that the wall collapsed because of the rain. No, they damaged my wall. They don't want to do my business. I have kindly peruse the photograph for a moment, your lordship. They are not, the respondent 1, 2, 3 is none other than my sisters, my husband's sisters. R4 and R5 is colliding, joining with me and they're sailing with me. R4 is here.
R5 is dead.
R5 is dead now. R5 recently dead, your lordship. No issues and no unmarried, issueless. He is my elder brother. He was with me only. I was taking care of him. He was unsold. I was taking care of him. He died. So now I am the widow. I don't have any source of income. I am packing the noodles and giving to the market. That's not letting me to have a livelihood. They're threatening me not to open the shop. From the death of my husband, they are not letting me to go near the shop. Now they have filed an IA stating that I am putting up the construction. Kindly peruse the photograph, your lordship. It's a dilapidated condition. I may be allowed to renovate. I'm not putting up any construction. I don't have capacity to put up the construction. I'm renovating the shop. It's a 14 by 40, size of 14 by 40, your lordship.
Please argue the main matter. It's a 2013 appeal. Here you on a near date. Yes.
Please.
Give a date. The main matter can be argued on that. Yes.
You have filed an IA this 2021, now 25. With the due respect to the court, I am out of the premises. R5, I will do it.
Please do the necessary.
Yes.
List it on a.
Yeah, right now I will do in the office of the. Though it's 2021, they have filed an IA.
Paper books are all filed.
Yes,
already.
21, they have filed IA. With due respect of this court, I am not going to the near the premises. Since the
Yes.
matter is pending, though there is no injunction, I am not going.
Yes, we.
Please final much. I will comply with the applicant.
2 weeks time?
Yes.
Yes.
I'm for the appellant, my lord. Copy of IA is not served to me, ma'am. Copy of the IA. IA filed by the respondent, my lord. IA 1 of 23.
For release of rental deposit.
Already there, order is already there.
Orders there on the IA.
Brother, come on. Then now, list for final area. Huh? ಹೌದು. Stated, Yeah. And just list for final area. The topics.
This matter is covered, may not by your lordship's order. May I just pass on the operative portion of the.
This is the MFF and the,
The GVPs,
yes, yes.
Grama Vidyut Pratinidhis.
Now you call them MFF.
Yes, yes. Micro feeder managers. Right. The judgment is not, most of it, not a very lengthy cost title is there. Please go to page 746.
Most of the judgment was the cost item.
I know, my lord. I think we must devise some way by which, my lord, we save paper. Because in Supreme Court, my lord, when they issue orders, they don't put the entire cost title in the order. If you want it, then you'll have to apply and take cost title separately. Otherwise, like in this case, my lord, 600 or 500 pages, cost title, my lord, every time.
Even the appeal was 2 volumes of cost title.
Correct, something. was
Even when we filed the appeal before your lordships, my lord, the cost title was running into 2 volumes. The actual paper started in 3rd volume.
The judgment started.
Some amendment to the rules, my lord, may have to be thought of for that. High Court Rule Committee. In a proviso can be added that in the case of batch matters, the certified copy will be issued in the lead case, and others who want it.
Yes, the suggestion is that the senior counsel advising the High Court can send a suggestion to the draft committee.
Because we request the report also in many applications, so that we can place that to the draft rule committee.
Now this
I have
we-
done,
we
my
will
lord.
take it up as-
I'll give this suggestion also.
Please, so that we can also take this up.
Please.
Because
Yes,
this,
sir.
Please, we'll do that. Now kindly go to the penultimate, very last sheet, my lord.
yes,
Page 746.
yes,
Your lordships have issued 2 directions.
yes,
In para 26,
yes.
may I read, my lord? In the facts and circumstances of the case, we are in agreement with the findings of the Adalat single judge that the contract being one of service, it can be terminated on allegations of malfeasance or misfeasance only after issuance of notice in that regard. The directions issued by the Adalat single judge are therefore upheld. The interim order dated so-and-so past is sustained and made absolute. The interim order, my lord, permitted us to take action if there is any misfeasance, malfeasance. The
Yes,
next
yes.
para.
Yes,
In the circumstance, we are of the opinion that appeals can succeed only to the limited extent of stating that the directions issued by the Irish single judge shall not be understood as directing regularization of GVPs and micro feeder franchises in sanctioned posts to which they may not be qualified as per the recruitment rules. However, we are of the opinion that the state is duty bound to consider recommendations high-level committee and to frame a proper scheme for fair wages and proper working conditions for GVPs engaged pursuant to its policies. The question whether the contract employees have the eligibility to be continued as against existing posts since they were admittedly carrying out statutory duties assigned to them shall also be specifically considered. The needful shall be done by state within 4 months from the date of receipt of the copy of the order. Order the learned single judge sustained. Same 2 directions, my lord, can be given and these appeals can be disposed.
Termination of these responsibilities.
and liberty reserved to them to take action in accordance with law after issuance of due notice, if required.
In our, my lord, their own communication states that because they have terminated on the only on the ground of inefficiency in collection. Then subsequently what happened? This is due to the software problem and they have to taken back, then one communication state that. In view of this, proceeding against these respondents is not correct. I will only may take your own two annexes.
Your case, na, very case.
Directed case 573,
You are in which writ appeal?
84,
84. 84, yes.
Because this is only the ground why they are terminated these petitioners for not. Yes, they were not because the collection was good. It was only at
Page number?
569.
Yes.
Dismissal of embezzlement who have entered inferior to it refers to the above second and informed in the letter that it has been directed to dismiss MFF working in area and actually within the purview of area division. As they have achieved inferior progress and in this regard, the following explanation has been brought to your notice and it is requested not to dismiss except serial number 9 be that one.
Keep the single judge's order.
The proposal has already been submitted to your office to dismiss B. Rajkumar from out of all members who have achieved inferior progress. The remaining members are achieving work progress in the remaining tariffs excluding LT1 tariff and they are reducing the arrears. LT1 tariff is going to be waived and the public are raising objections to the arrears of the installation. Hence, it has become very difficult to recover said that. However, arrears is being recorded by issuing intimation to the customer excluding LT1 tariff. Their work progress are under. It has been given in tabular form. Now, kindly see the next page, 573. Moreover, previously, Arthritis subdivision was completely transferred to impose this transfer and use
not being interfered with.
information.
He will have to get back on that.
Disconnected also due to several lapses of software.
And with liberty to hold it.
Lesson and present it was retransferred to any software now, building the story of the revenue being made regularly. Yes, recovery of the previous
Single judge put it.
and that
Reinstate pass ಮಾಡಿ liberty to hold inquiry. So that means.
Progress in that tariff. And it is requested not to dismiss the remaining MFMs from their duty for the
Stay ಆಗಿತ್ತು.
This is the internal communication act
Stay
as
ಹೋಗುತ್ತೆ.
annexure.
So this is
There
implemented.
is no requirement even after the passing of the judgment by the single judge Malodi.
You cannot decide. Those are issues. We'll say that you have pointed out annexure N. Those are issues if there is a requirement at all. You have to be put on notice. Probably this would be a reply to the notice. He cannot decide on those issues. We'll only say that the fact that it is a contract of service is now affirmed by us. And therefore, we will say that if there is any need for termination, it can only be after, even in contract employments, that is straight law, even if it is contract employment, if it is a contract of service. And the termination is on the basis of something which you have not done or something which you have done, which you should not have done. And a notice has to be issued and proper procedure has to be followed. Your explanation has to be. That is all. We will only say that it cannot be, the termination cannot be termination simpliciter because they had treated it as a contract for service. If that were so, the non-meeting of the terms by itself would entail termination of the contract. It cannot be in a contract of service, that is all.
Lord, may I draw attention, my lord, to what the learned single judge had done, my lord, insofar as this particular person is concerned. The very penultimate page of the judgment, it's at page 454, my lord. Direction number, Roman number 4. Page is internal page 454.
Yes.
And paragraph number Roman 4, my lord, bottom of that page.
Yes.
A writ of certiorari issue quashing the impugned termination orders in WP number so and so, with liberty to hold disciplinary inquiry within 8 weeks. If not found guilty, these petitioners shall be reinstated without any consequential benefits, such as back wages, counting of service, etc. So if he is entitled to this relief, it should be extended to him. That's all.
Lord, only one aspect, Lord, I would like to make is, Lord, no doubt, Lord, this order has been passed, my Lord, in the month of August 2020. Lord, for the past 5 years, Lord, they have not held any inquiry, my Lord, pursuant to the directions.
And you are continuing.
No, we are out of employment for all these years.
There's a stay order.
That is a very unfortunate part of the whole story. If they had.
These matters, somebody had submitted that those persons who are out of service should also be re-engaged. We had also passed such, the Earlier,
Lord,
bench had passed such. a-
Exactly. In some of those cases where, my lord, their services were terminated during the interregnum, that is during the pendency of the writ appeal. But in our case, my lord, the very question which was raised before the learned single judge was, my lord, regarding our illegal termination. So, my lord, we were out of employment from 2015. And now, my lord, we.
Say that they will decide whether
My lord,
termination is required or not
No,
in the present circumstances
the,
within a shorter time.
the effect of this direction, my lord, is that the termination order has been quashed. That was stayed by the honorable division bench. So that's why they didn't get the benefit of it. So today, my lord, if this portion of the order is sustained on these terms, then they will,
To be
they will
reinstated.
come back to work with this liberty given that we can initiate action within 8 weeks and
We'll-
depending on the
We'll
outcome.
record that.
That's
We'll say that they'll be reinstated and within 8 weeks, you can take.
in
action
terms of
against
this
them in
direction,
term.
please.
Yes.
All that we can hope, we can have the hope is that, my lord, it will be done immediately, my lord. So reinstatement,
In the other matters, I guess reinstatement
done.
has already occurred.
yes.
So please give them the benefit of the doubt. Yes.
Lord, if I'm not mistaken, Lord, I think in paragraph 26 of your lordship's earlier order, Lord, there is some mistake, Lord, if I'm not mistaken.
Is
Para 26, my lord.
Yes, that 684 is not the matter where we had directed.
No, in the concluded cases,
Yes,
I'll just read, my lord.
yes.
Further, in the facts and circumstances of the case, we are in agreement with the findings of the learned single judge that the contract being one of service, it can be, I think, my lord, it cannot be.
No, it can be terminated on allegations of malfeasance or misfeasance only after.
Yes, it's correct. I respectfully agree. It's
It
correct.
is correct, because,
I'm sorry.
yes, otherwise that would be a double negative. If I say it cannot be, then it would be a double
Very well.
negative and it amount to a positive. This is correct.
Please.
Please.
Yes, we've heard the learned hearing for the appellants, learned senior counsel appearing for the appellants in these matters, as well as the learned counsel appearing for the respondent. GVPs stroke MFFs, full stop. It is submitted by the learned senior counsel that the question raised in these appeals is covered by a judgment of a co-equal bench of this court, where one of us, authored by one of us, ASJ, within brackets ASJ. full stop. It is submitted that in batch of writ appeals, that is writ appeal number 34 of 2021 and connected cases. Judgment dated 24/1/2025. This court had held that the contract entered into by the appellants with the GVP stroke MFFs was a contract of service, and that such contract can be terminated on allegations of malfeasance or misfeasance only after issuance of a due notice. It is submitted that the learned single judge had considered the contentions of the employees, had held that the impugned termination orders would stand quashed with liberty to hold disciplinary inquiry within 8 weeks. And if the employees are found not guilty, they would be entitled to reinstatement without consequential benefits. Full stop. It is submitted that the said direction was stayed by this court in these writ appeals. Full stop. It is submitted that in view of the finding in the judgment dated 24/1/2025, the interim order of stay granted by the division bench in these matters will have to be vacated, and the orders of the learned single judge will have to be given effect. The learned counsel for the respondents submit that in many of these cases, there are findings that the employees were not at fault for the shortfall, and that there would be no requirement for conducting disciplinary inquiries against them. Annexure N, which is produced along with petition number So petition number 43037 to 43044 of 2015, which is the subject matter of Appeal 84 of 2020, is sought to be relied on in support of this contention. Having considered the contention is advanced, and in view of the fact that the learned single judge had quashed the termination orders and directed the conduct of the inquiry, and in view of the findings in para 26 of the judgment dated 24/1/2025 in writ appeal number 34 of 21 connected cases, we are of the opinion that the petition, that the respondents would be entitled to the same relief. The writ appeals are therefore dismissed. The directions of the learned single judge in the judgments under appeal shall be given effect to at the earliest.
Lord, one more point, my lord, where I thought.
10 weeks, my lord. Time may be fixed, my lord. Time may
You
be
want
fixed.
time to be fixed. Within 4 weeks, appropriate steps shall be taken within a period of 4 weeks from today.
Lord, one other issue, my lord, is I've been mentioning this many times, my lord, this cause list being issued, my lord, the previous evening, is causing a lot of difficulty, my lord. We get the cause list, my lord. For some days it was coming at 5:30. Now it's saying gone back to 8 o'clock in the night, 7:38. By the time, my lord, the officers are able to take out the file, and there's no time to contact. So, my lord, I've given a very simple suggestion, my lord, no change is needed in that. Is instead of issuing cause list on Monday for Tuesday, my lord, if it can be issued for Wednesday. So if on Monday some matter is heard by the Honorable Court which feels that next day it should be repeated, only that they can issue a supplementary list. Lord, if the lawyers have one extra day, lot of adjournments will be avoided. They'll say, I could not contact my client, senior counsel not briefed, file is not traced, and some application to be filed. All of this will get completely eliminated, because lawyers will have one whole day to see. Otherwise, now, my lord, sometimes we get the briefs for reading at 9 o'clock, 9:30 in the night. And next day, if it is item.
If the cost list actually comes out at 5 PM as it was being done, and that
Won't happen, my lord.
solves.
It's not happening, my lord. But this is a very easy, my lord.
Because as a matter of fact, it was happening for some time. We were under the impression that it's still happening.
Lord, in Supreme Court, my lord, this practice is followed. It should be uniform for all courts, my lord. In Supreme Court, this is happening very effectively, my lord. For Monday's list, by Thursday evening or Friday morning, the list is announced. The final list is known. And if there is something else which is directed by the court, they issue a supplementary list. And in the morning, my lord, on Monday, the Honorable Court will instruct the court master to put it on the ticker. What will be the sequence? Suppose there is some supplementary matter which the court thinks it should be taken up before other matters, it will be announced. So lawyers know that even if your item 1, because of this information, your matter 1 may not reach till 11:30, 12 o'clock. They'll adjust their work.
Correct.
And they'll have time to get ready, my lord. The very time-tested method. Friday list, my lord, is available on Tuesday. And that's the final list. But subject to orders of the Honorable Court, if any further matter is to be listed, some matters part heard today, Honorable Court feels tomorrow it should continue. Your lordships will direct, it will be a supplementary list. It will say, list for today, taken up at 12 o'clock, 1 o'clock, whatever, my lord. It's very easy methodology. I don't see any difficulty with the registry also.
That also gives time.
This is a request, my lord, which many of my lady colleagues, my lord, have been pressing me, my lord. Every time I meet the young lady lawyers, they say, sir, now we can't go home till 9:30. This is our problem. So this is
Something
a request.
we'll have to place it before
I'll put that also in my
the Chief
request.
Justice.
Please.
We can see what can be done.
Great.
Yes.
Hearing for respondents 1 week, request for weeks further time, file my objections to their affidavit.
On filing of documents.
We have filed our affidavit, my lord, as per the orders of this honorable court. My lord,
Last
but,
21st January,
my lord,
requesting 1 week's further time.
my lord, in view, some date may be fixed because,
Learned counsel for the respondent seeks a week's further time to file the documents in support of his contentions. List on
Can it be on 12th, ma'am?
12.
obliged, my lord.
Again, I forget.
Needful time for the weeks.
Sorry,
Needful done. Pay the.
done.
I apply for the appellant, but it's needful is done, so paid it. But let's, by the purchasers. No, appellant Mallards is for the purchaser. Respondent number 5 Mallards is the private respondent grantee. To him Mallards process Mallards is taken.
Covered by the purchase, your purchaser.
Yes, yes.
Purchaser for property.
Yes, ma'am.
I am also purchaser in expense number 30.
Was under the obligations transferred or filed by the petitioners to the public.
Filing application article.
However, petitioners are not entitled to restoration of the subject land as the application was filed after the original period. The matter is remitted for reconsideration of the appeal. Because sale is in, the sale is on 22/8/1957 is the first sale to you.
But
Is
let's
that the sale to you?
Yes, Mallards, if it is taken up for hearing, Mallards, a date may kindly be fixed, Mallards.
Why
I'll
should
also
it be sent back?
Yes.
Hmm.
The case is something.
That it
Remand
need
is
not be
back.
sent back, only with regard to the remand. So what notice has to go?
Here, taken steps.
I've paid it, Mallards, already I've paid. Obliged.
My lords, serial number 18, my lords.
Yes.
I am appearing for the respondent, my lords.
Hmm.
Well, as I have already served the copy to the statement of objection to the appellant counsel, my lords. That has not been taken on record, my lords.
IA for permission to prosecute the appeal.
That they have filed the appeal, my lords. It may be taken on merits, my lords. We will get ready, my lords. By coming week, my lords. The appellant has no locus standi to question the order of the learned single judge, my lords.
What is the finding of the learned single judge?
My lords, the writ petition, one more writ petition has been filed by the same appellant before division bench, that is in public interest litigation, my lords. It has been rejected, my lords. Then they filed the application before the learned single judge in another matter, my lords. It has been dismissed. Against that order, my lords, they have approached this honorable division bench in writ appeal, my lords. The excise license has been given to the respondent herein, my lords. My lords, sorry, my lords, we can't hear the.
The appellant is not present in court counsel.
Please, my lords.
There is no representation.
Date may be fixed, my lords, for hearing, my lords.
On the other date.
27-2.
Please, my lords, oblige, my lords.
For the appellant, my lords, I have done the needful, my lords. The only thing that was remaining is production of the claim petition, my lords. I'm producing the copy of the same.
It is done or not?
And I'm serving the copy of the appeal on, I'm serving the copy of the appeal on the respondents as well.
It is not the question, madam. What are the office objections? Have you complied or not?
Yes, my lords, everything is done, my lords.
The court officer, no? Non-compliance list is there. Where? Non-compliance office objection. Nodi, attraction. Whether it is complied or not, because peremptory order is. There is a note, office note. Office has to write. Otherwise, how can we come to know that it is complied or not?
It is filed last.
Then counsel for the appellant submits that.
Put up in the file, my lords. It is filed last week, my lords.
Then counsel for the appellant submits that all office objections have been complied. Registry to verify and verify. List on funds.
My lords, they had filed an IA for withdrawal of 50% of the amount, my lords. The amount is very substantial. It is 15 lakhs, my lords.
Only 15 lakhs.
I'll
They are
have
land
to file-
losers, no?
My lords, I'll have to file objections for the same, my lords. I may be permitted 1 week's
Madam,
extension.
you will not comply office objection from 2 years. They are land losers. They have to wait for you or what?
My lords.
What is the amount granted by the reference court?
My lord, the operative portion is at page number 27, my lords. 1,50,000 per gunta, my lords.
1 lakh
50,000 per gunta, my lords.
by reference court.
Yes, my lord.
Land acquisition officer,
Like 2,470.
award amount, how much was the award amount?
Like 2,470 per gunta.
50%. 50% you have deposited, no?
50% we have deposited, my lords, before the reference court, my lords. My lords, I may be permitted to file objections and the matter may be heard on merits, my lords.
Based on what this determination of compensation? You may.
Supporting
adjustment owner of the building is provision before the time. So award the only
8 guntas.
some other matter is.
They are relying on a different matter, my lord. It is a different matter altogether. The facts and circumstances are different.
Only 8 guntas.
Only 8 guntas.
Around 50% amount. How much is the amount you have deposited?
16.
15,48,698, my lords.
10 lakh. Record. Third on IA 1 of 24. Land counsel for the applicant submits that the respondent land was the respondent has lost his land in the year so not a preliminary notification date and he has not received any compensation. There is a dire need of money for his money, full stop. They submitted that the appellants have deposited 50% of the amount before the reference court as directed by this court, and he seeks to allow the application. By contrast, so and so oppose the application and submits that if the amount is released in favor of the respondent number 1, it would be, and if they succeed in the appeal, it would be difficult for them to recover the same. Hence, he seeks to dismiss the application. We heard the arguments of both sides, peruse the material of record. The reference court, on considering the rival submissions and the evidence on record, has redetermined the market value of the subject land at rupees 1,50,000 per acre. Per gunta, and the claimant's land measuring 8 guntala is acquired. The interest of justice would be met if the claimant is permitted to withdraw rupees 10 lakh during the pendency of this appeal. Reference accordingly, the IA is allowed. The reference court is directed to release rupees 10 lakh in favor of the claimant on he producing a proper identification. IA is disposed. Call for TCR. Yes. 10 lakh, madam. So that maybe around some percent.
Will be difficult to recover, my lords, in
Yes.
case we succeed in the appeal. That is the only.
This education matter.
I appear, my lords, in 20.2 and 20.3, my lords. This matter where, my lords, that in-service candidates, my lords, decategorization of seats. But your lordship may have it on 10th, my lords. They are submitting the representation. Your lordship directed, my lords. If they submit a
Lordship
representation, your
suggested.
lordship will direct.
Yes.
The Lords had suggested on the previous occasion that they give a comprehensive representation.
There is a comprehensive.
They are submitting it
representation.
today, my lords. Your lordship may have it on 10th. I will place it on record, my lords.
The,
Request, madam.
we'll say that the consolidated representation will be submitted by you within maybe a week. We'll
Please,
give you a week's time.
Today or tomorrow.
And then the same will be considered within a time frame, and at least in respect of the next year's selection, it will have to be, something will have to be.
If some guidelines are laid down by this honorable court, my lords, then my lords, mere
May not
direction,
be
my
open
lords.
to us to lay down guidelines as to how it is to be.
At least, my lords, with respect to
These
the
are matters which they have to consider. And if there is a lack of consideration, or if they continue to do this in this fashion, then probably it will be a matter for us to consider when as soon as the brochures are out.
certainly, my lords, what is happening, my lords,
That would be the
continuously from the
correct
past,
time
my
that
lords,
this
about.
must be considered. Next year, when the brochures come out, if this very same exercise is going to happen,
Consistently, my lords, every year, this honorable court, my lords,
when we tell them now how to go about doing it,
at least, my lords, the state government
actually
and the
be in
central
a-
government, my lords, has to work in tandem, so that, my lords, the reduction in percentile, my lords, is
Definitely
not
say
communicated along with, my lords, with the
that we'll
state.
say that those are your contentions, and we'll say that we think that it requires a consideration, which is why we are ordering it. In normal circumstances, we wouldn't say any of this.
Please.
It is because we notice the difficulties that are occurring because of this lowering and the giving up, not being in tandem. That we are passing these orders. We are directing them to consider.
My lords, my submission is this. There are DNB seats. This time they were given, allotted to DSC health hospitals, which have been given DNB seats.
primary DND seats and secondary DND seats, which are exclusively meant for in-service candidates and they cannot give it to anybody. Now, they have
Diploma-
allotted, yes, my lords, they have allotted only, now they are eligible, there are eligible in-service candidates. For those seats, they cannot be taken by the open quota. Now they are, what they have done is, in the allotment, they have allotted only 14 candidates and rest of them, they are there. Still, they have not given them. They have not.
I need to ascertain, my lord, because everything was decategorized.
These arguments when you're making offhand on each. I'll produce the document tomorrow, my lords. Because this is.
This
I
goes
got
on and on.
information
So
now, my lords.
these are issues that you can incorporate in your representations. We'll say that that will be considered and appropriate
This,
steps will be
this
taken.
time, once now, this round is over, my lords, they will reward them to, MC. They will reward them to all India quota. That's a problem.
No, my lord. Yeah.
After all India quota, that
Come here.
Now the mop-up round is also over.
Mop-up round here is over. How can they revert to the all India quota? There is no question.
It only has
Or
to
the
go to the
stray
next
vacancy
stray
or
vacancy.
the all India quota.
My lords, may I submit, my lords, this is not.
This is not subject matter of this writ petition. You did not raise it. Now
No,
you're
now
raising these
we got-
contentions.
No, my lords, they are trying to get it, but now I got the information, my lords, I'll place it before the honorable court. I have got the papers also now.
Then may we request my lords to have it on the 10th, my lord, by then at least let them formulate one
Place
representation also.
these contentions. We are at each posting date, we are being encountered with new contentions altogether. Things that are not there, the writ petitions are being thrown at us. And well, they have to, you have to put it to them, they have to come back and it's only then that we can decide. So at least if it's not put to them.
Yes.
The application is only confined to survey number
With regard
89
to
errors.
submission of a consolidated.
The petitioners that I represent is not concerned or not connected with the 89 errors.
Court officer,
Yes.
please.
What the legal counsel has made a submission that
Mr. Ravi Shankar, please mute here.
Yes,
My sincere apologies, minutes.
that's all right.
After 10.
So let's wait, let them produce whatever they want to produce. Yes, now the.
Minutes, I am sorry, minutes,
Widening at each posting. Yes.
Please.
At the request of the learned counsel appearing for the petitioners list after 10 days.
My lords, may I submit, my lords, this is interruption, sorry for the interruption since learned counsel, Mr. Ramesh has come now. In the matter, yes, on Saturday, your lordships heard and directed orally not to proceed with that because tomorrow your lordships are taking up the matter. Despite that, at 11 o'clock.
Lord, that's
they
a
have,
different matter.
Yes.
We have held up the whole.
No, my lords, it is, I have the printout of that.
Consider in the appropriate case comes up, counsel, if they were not complied,
I'll move the
they
matter, my
take the
lords.
chance. How else?
I'm sorry, my lords. I'll move
If
the-
they don't comply with directions of this court, we are well aware of the consequences, is all we can say. Yes. let
Minutes,
us-
I'm sorry, minutes, I am appearing in 20.1 in this matter, minutes.
Yes.
Minutes, lordship said, I am understand, minutes, yes. But your lordship had observed that there is already a coordinate bench judgment, minutes, pertaining to the previous year. Minutes, I went through the judgment, minutes, of the coordinate bench of which one of the learned members of this bench, minutes, he has authored the judgment. Now, that's a judgment which eventually falls out in favor of the petitioners because this honorable court takes, minutes, there are two things, minutes, of course, I may be wrong in my understanding, but what I understood of the judgment, minutes, is number one, it takes note of the circumstances which prevailed in Maharashtra. And so far as Karnataka is concerned, by referring to the brochure, it was specifically held that decategorization is not correct. And because there was an interim order itself, that decategorization should not be made. There was already an interim order. Then, minutes, the in-service candidates were permitted to participate in the counseling till the mop-up round is completed. That's the
We'll
direction.
consider on the next date.
Lordships.
because That specifically is not the judgment being referred to.
Another judgment, you are referring to another judgment.
Milords, because the other judgment which I am now referring to, Milords, is essentially the a judgment which covered the very same issue by referring to the earlier constitution bench judgment of Tamil Nadu case, Milords.
We'll
Next
consider.
date of, please, Milord, please.
Not myself or another judge. Because there was an interim order, hence we have given protection. Appellant matter.
2012 matter.
Yes, ma'am.
Who appears for the respondents? Ready? We have a parted matter. 21 is, 22 is parted. We can come back to you after that.
Yes, the judgment is done in Kannada language. So we're not-
Yes, my lord.
May require a translation.
Yes, my lord. Learned friend is right. At the request of
Get the
counsel for
translated
the
copy.
appellant, least week after next, to enable him to file a translated copies of the documents relied by him.
Please.
Can a date be fixed, my lord? I will positively file it during next week.
As soon as you file, you move it.
Yes.
Interim order request. Interim order request to be extended. Obliged.
24.
Sorry, we were not
Anand-
informed.
Ananda Krishnamurthy. 24, no?
24 only.
No,
I-
he has took time.
Ah, He didn't inform me, my apologies. Only interim order request to be extended in the connected matter. In their matter. it is
MFA
not there.
4227.
Yes, please. It is there already.
Interim order in MFA 4227 of 2017 will stand extended
Obliged.
till the next date of it.
That will take next week, my lord. ಮಾಡಿ ಏನು ಪೇಪರ್ ಬುಕ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಟ್ ಮೇ ಬಿ ಟೈಮ್ ಅಲ್ವಾ ಕೊಡಿ ಫೈಲ್
Garden lands not, 9 lakh not is awarded. Wetlands not, 5 lakh is
on what basis it is awarded reference court
reference.
redetermine on what basis
Can you take note? Judgment. Fine. Paper book is also filed. There were three witnesses, not PW 1, 2 and 3. 3 not is an horticulture, not a senior officer. He has given the evidence.
for tree it is then
Three trees, different survey numbers.
three trees malkis
Three market value of 3 not is also. Because there were standing not arecanut trees. According to not exhibit T3, the value of not each tree is not about 1,600 not 09 and 602. But not the trial court has taken only not 1,200 per not tree.
engage the AIG AIG age
2005 not the lands were acquired. Till today not there is no payment of. We have got not about 7 acres of land.
That is paragraph 10, LAC 11 of 2009. LAC 11 2009 is on the higher side. Is there any appeal as against LAC 11 of 2009? Where this 5 lakhs is given for, is there appeal against that?
This appeal not is as against not.
11.
11.
There are two appeals.
Yes.
MFA 7569 is against?
68 not is in respect of not 11 of 2009.
Yes.
6579 not is in respect of not
7569.
2 of not 13. LSC 2 of 13.
In 2 of 13, 11 of 2009 is relied on.
Same notification, same person.
Is there anything in 11 of 2009?
whatever the order not passed in 11/9 is applicable not to of that. Initially, not the division bench of not this on report, feeling not that the compensation awarded was too less, remanded not the matter back to the trial court to specifically consider not the exhibit P1 to P3, and also directing not to bring not the PW3 to give further evidence not with regard to value of the tree. That is when not after remand, PW2 and 3 were examined, and not the compensation not agreed.
51,867 per acre for wetland, 27,846 per acre for dry land.
Consent
Passed it.
consent award,
Hmm.
agreed to award is 6 lakh per acre for the consent, but later since there was no consent, the award was passed. Consent he has agreed for 6 lakhs. Award not was for about 6 lakh per acre, but when the consent was not given, they awarded not 37,000. But 9 lakh on what basis? 9 lakh not, on the basis of not the exhibit not P 16 to 20, no? 16 to 20. But the adjacent not village land not which were acquired not with the government. They paid not about 15 lakh not per acre. No, 16 is the proceedings of the deputy commissioner. Yes. SR value report 20. On the basis of SR
bills.
value not. So this is different. Date of acquisition, preliminary notification? Yeah. Preliminary notification is on which date? That was on not 35, not 2000. Why? 2005. 36, 2005. And survey, land was taken into possession not one a year early. 25,000. 2004 itself not. Before blood was lost.
Maybe day after tomorrow, may not.
In this case, only remand order is there. Yes, yes. Have you produced that? No, I have not. Next date, not I can. Bring that also. Only on Malkis it was remanded, not on the. It is remanded for what purpose? Remanded not, considering not that the value not fixed not earlier was too low. Value of trees or land also? Land and tree.
Land also.
I place it. Yavaga Arun?
Day after.
Small matters we can finish up this. Six two. Request of land SCGB list on 6-2. All these are from the same notification, no? Both are from the same notification. Two. And claimant is also same. Two matters, same claimant, huh? Different lands. Please.
And cross objection.
Railway limitation. Please.
Pass over, please. Great.
Here also land acquisition.
Inter-se dispute. Inter-se dispute, huh? Inter-se dispute.
Senior citizen will have to put this center, also get an application.
Application for what?
Probably hearing that.
He should come, no? Huh? What to do?
My lord, serial number 28, my lord, I appear for the appellant.
There is no representation for the appellant list.
Yes, this is 28.
Yes, my lord, I appear for the appellant. My lord, I'm requesting for about a week's time, my lord. I'll file my citations and argue this matter, my lord. In fact, we were ready, my lord. I'll just place that on record. Remember, small matter relating to, my lord, consideration of date of joining. My lord, whether trainees should get benefits as on the date they join duty or, my lord, the date of their confirmation. My lord, I'll place on record the citations and argue it, my lord, a week's time, please.
The request of learned counsel for the appellant. This next week.
Wait,
Next week, please.
wait, please, my lord. I'll place it on record. Wait.
14-2.
Yeah, with my lords, kindly, my lords, serial number 27.
Now we are 29.
No, I didn't seek for time, my lord. It's just passed over by the court officer. I was waiting. Time for the appellant.
28. 29.
It's 9.1. Yes, what is this about?
This is about the recruitment matter.
Hmm.
That back, as per the procedure, my lord, they placed into for IBPS, that's one of the provision, my lord.
Hmm.
And IBPS, they give the name of candidate who have been selected.
They conduct the selection and
Exam, they conduct the election, they conduct the return the states, conduct the review, and borrow the list of the
correct,
candidates.
correct.
That's an update submitted to the bank.
Yes.
Bank plays the intent of how many persons they want, or
Hmm.
banks.
Hmm.
And then they will send the list to the banks.
Hmm.
In this case, what happened, my lord, they sent the list to the bank.
Hmm.
And that as per the list, bank absorbed all people.
Hmm.
And some of few vacancies they did not die. And they have not followed the waiting list.
Hmm.
Then, my lord, then after absorbing all those people, then another 2-3 months for the next year, again they advertise.
Hmm.
Issue the advertisement.
Hmm.
Then whatever vacancies bank had, that you place the intent that vacancies. And these people.
Whether those vacancies were in existence at the time when the selection was being conducted, yes.
That is observed, yes,
Hmm.
people are not dying.
Hmm.
Their place, bank has not placed the intent.
Hmm.
Because one of the reasons why they place the intent is, because intent is depending upon how many persons we require, bank requires.
Hmm.
Now, that is depending upon the expansion and retirement and all those things.
Hmm.
Then, my lord, in this case, then there were some few people are not dying. There was no requirement. That bank has not placed the intent again to IBPS to send from the waiting list. And then, my lord, these petitioners, they filed the petition before the honorable court, stating that we have been that we were in the waiting list, and because the bank there was some vacancy in the bank, and they should have taken them in the service of the bank. The bank, the bank said no, because we do not have the waiting list, and there were no vacancies, there is no requirement, hence these people were not taken. And in this case, what happened? There is one of the conditions in the recruitment is this waiting list will be available just for 1 month, 1 year, or
before another advertisement is released. And on that day, after advertisement, after release of advertisement, automatically waiting list will be cancelled. They release the advertisement in the month of first after the next year. So because of that, my lord, that waiting list has already cancelled. After cancellation of the waiting list, then these people file the requisition. This honorable court extended time to consider that case. Even then bank filed the objection for vacation of interim order. However, the honorable court said that the application is heard along with the merits. This honorable court learned single gentleman passed order to consider that case for the recruitment. Against that order, this writ has been filed by us. That IBPS has filed the requisition because on this ground only, because that already time expired, and there is why there is no local standing for these persons who are in the waiting list to come before the honorable court seeking for employment. That is their case. Our case is also similar to that.
When did the vacancies, when did those vacancies where persons did not join become available? Is it within the 1 year? If it is within the 1 year of the life of the reserve list, why was it not communicated is the only question.
Yes, my lord, vacancies were there. We filed RTI also in some 6th or 7th month only. That also we have attached. In RTI also it was shown that vacancy is there. In all other states, they were waiting for the vacancies, but in Karnataka, they weren't. After that, on 1st January, they what sir said, it's correct. And on 1st January, they advertised again. And as per their policies, whatever, whether it is on the expiry of 1 year or the fresh vacancy advertisement is advertised, the waiting list will be, there will be no consideration for the waiting list. But the question here is, Lord, the vacancy were there. A lot of people didn't join. Then they were supposed to consider the waiting list. In waiting list, vacancies were there in October. They filed RTI, which shows there are multiple vacancies.
Before the expiry of the period of the reserve list, the vacancies did arise.
Yes.
But they were not intimated, is the only question. Yes. What does the learned single judge say on that?
My lords, I appear for the appellant, my lords.
Judgment of the apex court judgment division bench have clearly held that as to the importance of reserve list, wait list, and the right of candidates to others lists, and have concluded that the recruiting agency in those cases was obliged to operate the wait list and fill up vacancies from the candidates in the wait list reserve list. Therefore, owing to the aforesaid narrative, the interim orders granted by this court, existence of list even as on the date the affidavit of the bank and the information given under the RTI Act would all lead to the unmistakable conclusion that the petitioners in the facts and circumstances did have an indefeasible right. This is the only question. When did the vacancy arise? And did the vacancy arise during the currency of the reserve list?
Yes.
Yes. Yes. Please tell us your answer to this. When did the vacancy arise?
Vacancy arise before the expiry of this period.
If that is so, then what else is the purpose of having a reserve list at all?
Without this bank is not included on
You don't have to receive it. You only have to notify them that only have to notify them that we have so many vacancies. Reserve list, you will get the requisition from the reserve list.
Not the first time they are doing like this. They are multiple.
Please, let us hear the appellants. Yes.
The reason why is that
I'm sorry.
You are for the IBPS?
Yes, I'm sorry.
We'll have to hear you first.
Yes.
Yes. And the second appeal is by the bank. Yes.
Kindly see the points for consideration the learned trial judge, learned single judges. It was not pleaded by any one of us that there is a res judicata that is applicable to the facts in issue. What had happened was, to put the matters in a nutshell, madam, may I request my lord to kindly see in page 99. That's where all the dispute stems from.
Annexure C. Annexure C.
Yes, madam.
Yes.
This is RRB 6. notification, allotment. Kindly see the second paragraph, last 4 lines. The spirit of government guidelines on reservation policy, administrative convenience, etc. The validity of CRP for RRB 6 will automatically expire at the close of the business on the day which is 1 year after the date of provisional allotment, or until a fresh provisional allotment is made, whichever is earlier, with or without giving any notice. Next one. Indicative post-wise, category-wise vacancies of each of the rural bank are given wide annexure 1. Recruitment in RRBs is a dynamic process which depends upon the restriction imposed, business volume, business growth, health of the organization, branch expansion, internal, external factors, structural changes. Vacancies mentioned here are indicative and anticipated as communicated by the RR. However, provisional allotment will be made based on actual vacancies reported by the RRBs. This is dated. 3 dates are relevant for consideration of this appeal. First date is 22/7/2017. This annexure C, which I read to my lords, is dated 22/7/17.
Date of the notification.
Yes, madam. May I request my lord to kindly see 153, ink page 153.
Yes.
That is the provisional allotment was made pursuant to this RRB 6. That is dated 1/2/2018. madam. That is dated 1/2/2018. Now, the life of this was 1 year, or till such time we come out with the next notification. My lords may kindly now see ink page 363.
Yes.
So this RRB 7 notification has come into effect on 1/1/2019. So therefore, the present petitioners have approached the learned single judge on 29/1/2019, secured an order on 30/1/2019. Therefore, this order of the learned single judge is non-est so far as the effect of this notification, that is RRB 7 dated 1/1/2019 is concerned. Because the life of the earlier 6 was for 1 year or till such time a next notification. This notification has come into being on 1/1/2019.
Whichever is earlier.
Whichever is. So therefore they have approached this court. So based on these factual matrix, I pleaded that similarly circumstanced persons approached Honorable Supreme Court under Section 32, Article 32, and it was heard. The Supreme Court dismissed.
My lord, that was a different case.
No,
Hear you.
I will not.
Yes.
Just sit down, I will complete. I have produced these Supreme Court. The learned single judge misconstrues the entire factual matrix and says that res judicata. I never argued on res judicata because the persons who were there are different from the petitioners. So the question of res judicata was not pleaded by me, nor was it argued. We only went on the footing that propriety demands that they are similarly circumstanced, and the apex court had already dismissed similar prayer made by same.
By a speaking order?
No, it was heard after a long time, then it is heard and dismissed. It was not on the first day. It was in Supreme Court for a period of about 6.5 months.
It was a writ petition.
Writ petition.
Under
I have
Article
produced that order at ink page 360. Now, my lords just saw 363. Kindly see 360.
We see no reason to entertain this petition. The petition is dismissed.
This happened, my lord, on 1/7/2019. So a group of persons suffered this order on 1/7/19. Another group of persons came to this honorable court on 29/1/2019. But they had filed this petition much earlier. So the point for consideration by the learned single judge is a miscarriage of justice so far as my submissions are concerned, because we never pleaded res judicata. Half the judgment is reflecting, captures various aspects of res judicata, which was not pleaded and argued. Therefore, that point requires a revisit.
What do you say on the merits of the matter?
Merits, the first point that I have urged is that so far we are not an instrumentality of the state. We don't take any as financial assistance from the state. Therefore, I am not a necessary party. The Supreme Court, in a similar circumstance when IBPS has only been a party, has held that writ petitions are not maintainable. Various courts, Kerala, Madhya Pradesh, Bombay, Calcutta, all are held that writ petition is not maintainable so far as IBPS is concerned. The fact, the crux of the matter, my lord, is they were in RRB 7, they were taken as, they were considered in the reserve list.
In RRB 6.
RRB 6. So they were there. It's an admitted fact that they are in the reserve list, waiting list. What happened was, 1/1/19, we came out with RRB 7. So the question of whether they get a right in view of the right flowing to the next allottees, evidently, demonstrably, they are not parties here. So the right has already accrued to the candidates who have been selected, and no order is made so far as that recruitment is concerned. The order that is made, kindly see the interim order passed by this honorable court by the learned single judge. I have one synopsis I supplied, if my lord were to kindly take it.
Yes.
Along with it. The respondents are directed to keep the requisite posts vacant, and also validity of the panel shall not be treated as expired as on 31/1/2019 is the nature of the interim order passed with the learned single judge. So that interim order benefit the petitioners / respondents herein cannot avail. Kindly see, I will read it again. The response are directed to keep the requisite posts vacant. We could not have kept anything vacant because the RRB 7 had already commenced as on the date of presentation of the writ petition. RRB 7 came into being on 1/1/2019. The writ petition was filed on 29/1/2019 and the interim order on 30/1/2019.
Excuse me, sorry. What does the learned single judge say about the
Doesn't capture.
Whichever is earlier clause?
All this is not succinctly captured at all. This is all the crux of the matter is only this. The learned single judge feels that if you are in the subsequent notification, if you are going to notify for the similar posts, the persons who are already now in the waiting list should be given an opportunity to represent. That's all is the.
Reserve list to the extent of vacancies as per extent provision will be drawn in each category, subject to exigencies and availability of candidate. This does not guarantee provisional allotment to recruitment by RRB. In the event of the RRBs providing further vacancies, provisional allotment will be carried out for the candidates in the reserve list, subject to vacancies being provided within 1 year after the date of the provisional allotment. However, if no vacancy is furnished by the RRB owing to exigencies or otherwise, during the validity period, the candidates under the reserve list will not be considered for provisional allotment. Reserve list will expire automatically on the day which is 1 year after the date of provisional allotment, or until a fresh provisional allotment is made.
Yes.
Whichever is or until a fresh provisional allotment is made, whichever is earlier with or without notice. Therefore, it is not on the fresh list being notified. I mean, fresh selection being notified.
The notification of this thing itself is called allotment. Kindly see the document.
However, if no vacancies furnished by the RRB owing to exigencies or otherwise during validity period, candidates under reserve list will not be considered for provisional allotment. Reserve list will expire. This is the
Crux.
crux. Reserve list will expire when? Automatically on the day, which is 1 year. That would be only 1/2/2019.
Or the
Or-
notification. Kindly now come to 363.
Yes,
36.
Or until a fresh provisional allotment is made, whichever.
Kindly see 363. The word, man. Provisional allotment of office assistants for CRP, sir. So we, instead of saying notification, we call it allotment. So therefore, the day when they approach this honorable court,
Whichever is early. So if this is the allotment, if this is
That's
the
the-
provisional allotment of offices.
we have understood the,
Yes.
On
as soon as
1/1/18,
RRB
and they come on 31st 1.
29/1 they approach this court, 31 they take the interim order, by which time the RRB 7 notification had already, that is point number 1, man. Now kindly see the learned single judge, ink page 30, man. These are the points for the consideration. He
Yes.
formulates. Formulation of point number 1 may kindly be considered. This
Yes.
is whether the writ petition filed under so-and-so is not maintainable on the ground. Petitions filed under Article 32 of the Constitution of India have been dismissed in limine on the same set of facts and prayer. But
Yes.
while answering, the learned single judge goes on section 11, res judicata and all that he says. It was not pleaded.
It was not between the same party.
They are not, it's not by the same party. So question of res judicata does not come. I was only arguing and I had only pleaded on the question of propriety. It is not that the day of the filing petition under Article 32, it was dismissed. It was heard during a passage of time. And same notification was challenged. RRB 6 was in challenge before the apex court. So I submitted that a different view, though is permissible, is not desirable. This was the argument. Second consideration, my
When you
lords.
ask whether it is maintainable or not, the answer. would be-
Maintainable.
Be maintainable.
I never said it is not maintained. That's the reason why I'm now, my humble submission is points for consideration only if there is a deviation and a departure and the focus is lost. Because our focus was not on this. We never focused on res judicata. The learned judge put upon himself. Second point for my lord's consideration. Whether the petitions have a right to be considered for appointment in the light of the fact that they were placed in the reserved list and whether the action of the bank depicts illegality in the sanction process. So the point for consideration ought to have been whether this notification stands the test of time. That is RRB 7. And the RRB 6, would it yield to RRB 7 should have been the point for consideration. That has not been made. Therefore, there is miscarriage of justice.
Any right. They're relating that way. it should have-
And the rulings of the apex court on this, I have supplied my synopsis. My lord, may kindly see the third judgment at the first instance. And the first judgment is to the effect that my clients, they do not become an instrumentality of the state and no writ petitions are.
There is a Supreme Court
Yes, ma'am.
judgment to that. effect.
Yes, madam. The first judgment, now that my lord,
2019-14 SCC 189.
yes, my lord. Kindly see Chairman Institute of Banking Personnel Selection, Mumbai. Same.
Yes.
May I read the headline, line 3, ink page 8, my lord. Ink
Yes.
page 8. I have
Yes.
given- Yeah, lady. Held mere regulatory control under statute or otherwise would not make the body state under Article 12. A respondent Institute of Personnel Selection conducting selections for appointment to public sector banks, whether state within the meaning of Article 12, not constituted under statute, nor receiving any funds from government, nor there existed any deep and pervasive control by the government of India, as there was no control of government or responded in any manner, respondent would not state within the meaning of Article 12. necessity held writ petition Article 226 is maintained even against private body, provided it discharges public functions. Respondent institute a personal selection, set up the purpose. I request my lord to kindly, ink page 9, para 2. There is no manner of doubt that a writ petition Article 226 is maintained even against a private body, provided it discharge public functions. However, it is not easy to define what public function. It can reasonably be said that such functions as are similar to closely related to those performance with the state in sovereign capacity are public functions. Then ultimately it is decided in ink page 13, para 13, whether the objects of the respondent institute is ink page 13, para 13 of the judgment. It's culled out. Then in para 15, line 4, there is no dispute the respondent is not constituted under the statute, and ultimately they dismiss the writ petition against IBPS. In para 23, they lay down the law. In page 16, para 23. The respondent institute has been set up for the purpose of conducting recruitment for appointment of various posts in public sector banks and other financial institutions. Applying the test mentioned above, we are of the opinion that the High Court is right in holding that the writ petition is not maintainable against the respondent. Conducting recruitment tests for appointment in banking, other financial institutions is not a public duty. Respondent is not a creature of statute, and there are no statutory duties or obligations imposed on the respondent. The learned judge does not answer this. I have taken a specific stance. I have supplied all the judgments of the various high courts, including the apex court. Same judgment was placed before the learned single judge, but there is absolutely no reference to.
Yes.
My lord, kindly now see last judgment. That is ink page 26, my lord. This is 19/5/2023. It is disposed on 19/5/2023. The matter from Karnataka, having similar set of facts, ink page 27, para 4, just to get the facts. Ink page 27, man. The last judgment, State of Karnataka versus Bharati. If my lord were to ink page. Alla, idu illide hege.
Synopsis dated 7/11/24.
Along with the synopsis added. Ink page 27, para 4. A respondent request for appointment is rejected by the state on the basis of proceedings of government, which provides that additional list shall remain valid up to 6 months from the date of its publication or the date when all the posts are filled up, whichever is earlier. Since additional list was published on 29/2/16, it would be valid up to 28/8/16, as the respondent made a representation only on 8/9/16, which was beyond the 6 months period. The request of the respondent was rejected. This decision was challenged by the respondent before the Karnataka KAT. Tribunal dismissed the application by relying on the proceeding. Decision was challenged by the respondent before the High Court. The High Court allowed it. Therefore, it came to Supreme. Kindly now see ink page 30, para 2. The selection authority shall prepare an additional list of candidates not included in the main list, not exceeding 10% of the vacancies available. The list so prepared shall be published in the official gazette, shall cease to be operative from the date of publication of notification for the subsequent recruitment of primary school teachers under these rules or any other rules specifically made for the recruitment of primary school teachers. Ours also, we fall into similar set of facts. Next, relying on entry 66, it is submitted on behalf of the respondent. Additional list would continue to subsist till a subsequent notification for recruitment of primary school teachers is issued. Last 2 lines in para 9. Mere publication of additional list does not create any right to be appointed. There is no such mandate in the rule. The law, ink page 32, para 11. They decide the matter like this. Para 11. The position that emerges from the above decisions is that the duty to fill up vacancies from additional list, waiting list, can arise only on the basis of a mandatory rule. In the absence of such a mandate, the decision to fill up vacancies from the additional list is left to the wisdom of the state. We will, however, add that state cannot act arbitrarily and its action will be subject to judicial review. Para 10, my lord, if I may draw my lord's attention. Para 10, ink page 31. The position of law is also clear in Shubha Nair versus State of Kerala, which has also been relied upon by the state. It has been held that a decision on the part of an employer whether to fill up the existing vacancies or not is within its domain. On this limited ground, in the absence of discrimination or arbitrariness, a writ court ordinarily would not interfere in such matters. Similar view has also been expressed by this court in K. Tulasidaran versus Kerala State Public Service Commission, so on so. Now I have one more judgment for my this Subha, which I just brought. May I just? I'm not. Just see. Just see, it's not that I give you. Last point.
Malats, may I make one request, Malats? I'm sorry, Malats. Serial number 57, list 3, Malats, I had mentioned it to today, Malats. No, Malats.
You are not appearing. We are drawing surmises from the voice.
I'm sorry, Malats. Am I visible now, Malats? I'm
Yes,
sorry.
yes, you
Malats,
are.
serial number 57, Malats, I had requested for today, Malats. I had mentioned it on Saturday and your lordships had posted it to today, Malats. Malats, today it's adjourned to 10. Tomorrow is the last date, Malats.
Tomorrow. It is of that court
Yes, court all one matter.
tomorrow.
Meanwhile, permit me to comply the office objection, my lord. Meanwhile, permit me to comply the office objection.
Great.
Great.
They continue now.
Code officer? Can we continue?
With my lordship's permission, may I make a request for adjournment, my lord? Serial number 31.
31.
List 1, my lord. I am for respondent number 4. Seek a week's time. My lord, I am not able to hear the court, my lord.
Yes, yes.
B.
At the request
Yes, my lord. Serial number 30. Much up.
Respond
Yes.
number 4. List next week.
Much obliged, my lord.
Yes, please. Please, sir. Yes. 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 Hmm.
In the aforementioned situation, loses all significance. They would assume that as per the definition, 9 more vacancies could be filled up, but it is right that if the employer takes a policy not to fill up any existing vacancy, only because person's name is shown in the select list, staying by itself to be a ground to compel the line.
Is not the question here. That is, according to us, not the question here. Question is, we understand. The question is this. If, as a matter of fact, the vacancies had arisen and there was a list in existence, the provisional list or the wait list or whatever you call it, and there is no other notification issued or allotment, as you call it, is not issued, then these vacancies are liable to be filled up from the wait list which is in existence. Absolutely. So that is what your notification also says. Therefore, if the second list is in existence, then the situation would be different. But therefore, the question whether they want to fill up the vacancies or not doesn't arise here. They do. They do want to fill up the vacancies. They have notified it also. Yes. 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 Yes.
Shown after the expiry of the line, vacancies should not be directed. I just wanted to. Now coming back to the single this differences that are gone.
Yes.
It all starts from page 39. But I have already read 40-41 directly from the notification.
Yes.
Skip those repetition. And there was a location where the single judge directed the bank to file an affidavit, just to indicate so that how many vacancies are still left. So the bank, in obedience to the order, the board also filed. Then it mattered that clearly, very clear, that some vacancies were still left. If the notification was not there, they could have been out. That was another judge thinks this way. Whereas the P in page 55. So there is no right. What is required? There has to be an absolute. That point is completely missed with the net. Therefore, though in law, para 30 of the judge,
yes,
the petitioners would not get an indefeasible right, but in the facts and circumstances of the case, the right to petition was available and the respondent bank deliberately chose not to operate the disseminate and grant appointments to the petitioners and called for a fresh recruitment. The very next year for the same vacancies. Therefore, the legal right of the petitioners is crystallized in the illegality committed to the respondent. I beg to submit that this is an incorrect inference. There is no right, much less an absolute right. So what is also relevant, the learned judge in line 2, paragraph 13, says that there is no indefeasible right. But unfortunately, in the subsequent paragraph, comes to a conclusion. That is in paragraph in page 65. The inference is that they have in the indefeasible right. Therefore, both the minor operative lines are more in the nature of certiorari. The only stated mandamus. I will just take my God and close my side. In page 65.
Yes.
Judgment of the apex and the judgment of the division bench clearly held as to the importance of the result weight the right of the candidates follows this and have concluded that the recruiting agents in those cases was obliged to operate the weights fill up the vacancies from the candidates in the weights results. Yet, going to the aforesaid narrative, the interim orders granted by this existence of this, even as on date, the affidavit of time, information given on the right to information, would all lead to an unmistakable conclusion that the petitioners, in the facts and circumstances of the case, did have an indefeasible right to get the candidature considered for appointment to the post that they have applied for. Therefore, I answer, mandamus is issued the ban to consider the case of the petitioners for found eligible in the service, offer them appointments. That is game. Moving away from the natural. So, indefeasible right, the learned judge of the earlier point in time, paragraph 13 says it is not. The last concluding paragraph, while he is making a remark, he says it's an indefeasible. The learned judge does not go into the notification, the content of the notification, the effect of the notification. All that is not there. He places reliance on a division bench rule and an apex court rule. And first point is the wrong answer regarding that. Procedural. The second point, the judge does not see the notification. So there is a boundary view that is expressed in paragraph 13 and the last paragraph. And the point for consideration, as the Lord will get it right, in page 39, whether the petitioners have a right to be considered for appointment in the right to the family based on the result. Obviously, no, as per the apex court judgment. It is not the absolute right that they can. Therefore, I beg to submit.
Only contingent right, absolutely not within the validity, the list is not issued.
Absolutely. If the list had not been issued, then
Yes.
correct.
Notification does not say the result is to be on. It closes, it terminates, and a new set of rights are awarded. It stems from the date of notification. And those persons are already are having an existing right.
Yes.
And
Yes, what do you say? Bank, your appeal. You adopt the arguments? You adopt the arguments? Yes. Yes.
original allotment will be carried out for the candidate to do it subject to dates or 2 years after the date. Or it is extensive. Otherwise, the candidates and the program
Yes. Yes. Hmm.
It is submitted that the applicants did not place further intent to recruit the place of the person who did not join the services, as there was no recruitment of additional staff for the following years. Number one, the original position of the applicant bank had come from the issue to 1880, and there was no branch inspection during that period.
This is incorrect.
Why not then think?
They notify in the next election.
Every year intent is not an issue. In the month of May,
That is not the issue at all. As a matter of fact, you do notify those posts. That is not the issue. Yes. Hmm.
Hence, the appellant did not put it further to pay intent to reach this other point of one, as there was no immediate requirement.
It's not your case at all. As a matter of fact, you did place intent. The only thing is that in the meanwhile, the new provisional allotment had come into existence. That is your case. Not that you did not require to fill up the posts. You did notify the very same posts also, but those came to be the subject matter of another notification of another allotment. That is your case. Am I right? If that is so, this is irrelevant. If you did not notify, if you feel that there are vacancies, but we cannot notify, that is one issue. Here is a case where, as a matter of fact, you had already notified. They had given you the list for filling up those vacancies. You filled up those vacancies. In the filling up, there arose some vacancies due to non-joining. Those are the vacancies we are talking about. You did not take a conscious decision not to fill up those vacancies. You did, as a matter of fact, notify those vacancies also for the subsequent selection. They issue a notification for the subsequent selection. The contention is that that notification is the next provisional allotment. If that next provisional allotment has occurred, that means that the reserve list in the earlier recruitment goes. That is the case, that we understand. But the other questions were not the subject matter. The legislative judge says those vacancies were in existence and you had notified also. Well, that is the accepted facts. You cannot go against the accepted facts in a case. That will create further confusions. That is not the case. The question is only this: did the second notification take away the right in the reserved list candidates in the prior notification? That is a question they have to answer. Please don't shift the focus. Yes, yes, yes. Now tell us, what do you see? Which is the writ appeal you want us? 640. Just a moment. 647. Yes. Hmm. Yes. Yes. Question is not whether vacancy was there. Did the banks notify the vacancy within a year? This is the provision. In the event of the RRBs providing further vacancies, provisional allotment will be carried out for the candidates in the reserve list, subject to vacancies being provided within 1 year after the date of the provisional allotment. So from the provisional allotment, within 1 year, if they reported those vacancies, said that these vacancies are present, even this judgment says, then I don't know whether there was any specific provision to that effect, but the judgment says if it is reported within 1 year, then it has first to be filled up from the reserve list and thereafter notified. That is what this judgment says. In your case, is it your case that these RRBs actually notified those vacancies within 1 year? No, they did not notify. Therefore, what happened? How did there is a fresh allotment which is provided. The provisions are these, in normal service parlance. What happens is if there is a specified number of vacancies notified, in normal situations, the rank list can be drawn up to fill up those vacancies and none else. It is only when there is a provision in the notification or the statutory provision which says that this rank list, which is prepared for filling up those specified vacancies, can be used for filling up other vacancies as well, subsequently arising vacancies as well, that you would get a right. Otherwise, the right is just this, to be considered against the notified vacancies. This is the normal service part. Here what happens is, the notification says, but there will be a reserve list. And if the RRBs notify the vacancies to be filled up, then the reserve list will be acted upon for filling up those vacancies which are notified. The RRBs, according to them, don't notify. Or for whatever reason, they don't notify. The vacancies are there, they do not notify. They notify those vacancies to the selecting agency for a fresh allotment. That fresh allotment comes into effect. What is the provision in the notification or elsewhere which says that that cannot be? Because the general rule is this: whenever a vacancy arises, anybody who's qualified as on the date of occurrence of that vacancy would be entitled to apply for that vacancy. Therefore, somebody who is thereafter been qualified for the appointment after your selection would also have a right. Here is a case where they notify and another selection is being conducted. What is wrong with that? That stay order will not help you unless you can show us the right. Please show us the right in the... What is wrong with that? If the notification says that the list will be in existence till 1 year or till it is notified again, whichever is earlier, what is wrong with that? That, according to us, is more conducive to 14 and 16 than the proposition that you are laying down. Is that not much lower in standard than the right of a person to participate for selection for public employment? Somebody who becomes qualified thereafter has as much a right. What is a right? To be considered in the selection on an even playing ground and to be included in the list. So even inclusion in a list, not just the waiting list, even inclusion in the main select list does not give you an indefeasible right for appointment. If the bank feels that we cannot fill up the vacancies for some reason or the other, if that reason is found to be just and proper, they need not fill up the list. Absolutely, but that is not the question. Question is, what would be your right to say that you are entitled for appointment? To be entitled for appointment, the situation must be that this notification should give you the right. Correct? Now, the right is simply this: to be considered for posts which are notified by the RRBs within a year. You admit that the RRBs did not notify within a year. Then what would be the right? The right would be, if there is no notification, no further notification, no further allotment, as is the language, no further allotment before the passage of the 1 year. If that notification also does not come, then you have a right to say that those vacancies which should have been notified and you should have been selected. You should have been considered against those vacancies, not selected. Considered against those vacancies. But the notification itself says it will lapse on the passage of 1 year, or when it is, yes, it is allotment, another provisional allotment is carried out, whichever is earlier. So the whichever is earlier, the first part and the second part happened first. What would be the illegality is my question. Cannot be for the simple reason that they are not duty bound to appoint from this list. If that were so, you're right. If the rule or the notification says that all the vacancies which arise during the pendency of this list, that is the language in the Kerala Public Service Commission rules of procedure. The rules say that every vacancy which arises during the currency of the rank list will be filled up from the list. The currency of the rank list is 3 years or till a new list comes into force, whichever new list comes into force, whichever is earlier. That is the language of the rules in the Kerala rules. If there is such a right, and if the new list has not come into force, then what you're saying is correct. There is a right to be, but then that is called a provisional allotment, is what they call it. But this is the difficulty. Please see the language. The notification speaks about the reserve list will expire automatically on the day, which is 1 year after the date of provisional allotment, or until a fresh provisional allotment is made, whichever is earlier. So now please see, which is that page of that. Provisional allotment of office assistance multi-purpose under CRP RRB 7 notice. Provisional allotment has been done based on the category-wise vacancies for the post. Provisional allotment means the allotment of the vacancies that has occurred. What is stated in the notification has already occurred on 1/1/2009, whichever is earlier. So now how do we get over that? That is the requirement of the rule. It is not correct. Please see. It is not correct. Please see page 363. It is an allotment. No change in the data already registered by candidate in the online application form is possible. If it is only calling for the applications, how is such a clause even remotely maintainable? The said provisional allotment has been done based on merit cum performance, keeping in view the spirit of the various guidelines issued by the Government of India, others from time to time, administrative exigency, candidate belonging to reserve category. It is an allotment. It's not a call letter or an advertisement for allotment. It is an allotment. If allotment has happened, that is the end of it. Please see page 363. Recruitment process has already taken effect, and this is the allotment. Provisional allotment under CRP RRB 7 has been done based on category-wise vacancies for the post of OA furnished by RRBs, subject to availability. Candidate can view their result status on IBPS website by entering their registration number, roll number, date of birth, or password. Therefore, the allotment has happened. Therefore, we have to presume that the advertisement came much earlier. Therefore, these very vacancies, which were not filled up, stood advertised, another selection conducted, another provisional allotment happens. Makes a world of a difference. So now what do we do? Right. Again, let us remind you, there is no right. How many decisions do you want on the point that a person empaneled for appointment after conducting a selection procedure does not have a right for appointment? He only has a right to be considered for appointment, provided the rules permit it and the employer is willing to fill up the post. This is the provision. If 26 vacancies were notified, your right is only to be considered against the 26 vacancies. Those 26 vacancies, if you're considered and you don't reach the cutoff, then the notification ends by itself, unless there is a provision like this with regard to a waiting list, a reserve list, whatever. Now, here is a provision with regard to a waiting list, which says that once the next provisional allotment comes, all rights ceases. The provisional allotment does come within the period of 1 year, whichever is earlier. Provisional allotment defeats the period of 1 year, and therefore the provisional allotments defeats all rights of the existing waitlisted candidates. They don't, again, it is not as if they have to make the notification specifically for filling up from the reserved list. They need not. They can, there is no difficulty in their notifying it for a fresh selection. They can. If the fresh select list does not come into existence, fresh allotment did not come, then what you're saying is correct. Just in case the new selection does not fructify within the 1 year period. And they want to fill up from the waiting list. Because a waitlisted candidate in the first selection cannot have a higher right than the first rank holder in the second list. He is more meritorious. That's why I said that argument may not stand. They've already notified and they've already selected also. That is not the point. Point is, does this inclusion in the wait list give you a higher right than a person in the origin, in the real list who comes as rank number 1? No. You are only a waitlisted candidate. You did not have the qualification for the merit to be included in the real list for the appointment. All those included in the real list were actually given the right for being appointed. Some of them did not join. That does not give you a right to say that they shall not conduct a fresh selection for those posts. They can. That is what unless of course, the rule says. If the rules say that this has to be in respect of all pending vacancies as well, all vacancies which arise during the currency of the list have to be filled up from this list. If that is what the rule says, it is correct, because that is the reality of the situation. Because a PSC selection will take years together to complete because of the sheer numbers involved. That is not the case with a banking selection. It can be conducted year on year. And a person who has the highest merit in that list, in the RRB 7, will now have to be pulled down in the vacancy position to accommodate somebody who's in a wait list of an earlier selection. It's not the intention. That cannot be the intention. If there's anything you can show us, we'll listen to you. But this is the fact. Don't go on the pleadings on the matter. This is the issue. Can somebody who's in a waiting list in an earlier selection say that somebody who's in the main list in the second selection should await them? When do you want? The shortest possible time. A little too long. A little too long. End of the week, or at least next week. Beginning of next week. 14th is also a little too long. Can we have this on 11th? 13th? List for further hearing on 13th. It's a case that is won it's a case that is won before the learned single judge. We shouldn't take him by surprise. Absolutely.
Writ petitions and writ appeals. Writ appeals are filed by KIADB. And writ petitions are referred by the learned single judge because of divergent views of different benches, single judge benches.
Yes. What is the question referred?
Question is regarding initiation of land acquisition proceedings under the KIAD Act. Whether, my lord, I'll just. Submissions.
Photos.
Not 2006 SCC, my lord, page 371 is the decision of the apex court in Kenchappa's case. Now, can I request my lords to take one synopsis that we had filed on 30th August 2021?
Yes.
Lord, while disposing of, my lord, some civil appeals, Honorable, my lord, Apex Court
ನಮ್ದು ಸಿನಾಪ್ಸಿಸ್
30 August 2021.
21.
thirtieth, my lord, 31st, 30th August 2021.
21. ಅದು ಇನ್ನ ದೊಡ್ಡದು.
ಇದರಲ್ಲಿ 531 ರಿಟ್ ಅಪೀಲ್ 531 ನಲ್ಲಿ ಕೋರ್ಟ್ ಆಫೀಸರ್
531
WA 531 ಅಂತ ಇದೆ, ಅದರಲ್ಲಿ ಹಾಕಿ
531 ಅಲ್ಲಿ ಹಾಕಿರಿ.
Yes, 31/8/21.
Yes.
Yes,
Can I request my lords to kindly come to page number 2 there?
yes.
On 5/10/2012, my lord, the learned single judge, my lord, disposed of the writ appeals, writ petitions, allowing the writ petitions and quashing the notifications. My lord, the learned single judge has referred to the directions issued by the, my lord, Apex Court, that I have copied there. Para number 100 is copied there. This is the direction issued by the Apex Court, my lord. The importance and awareness of environment and ecology is becoming so vital and important that we, in our judgment, want the appellant to insist on the conditions emanating from the principle of sustainable development. We direct that in future, before acquisition of lands for development, the consequences and adverse impact of development on environment must be properly comprehended, and the lands be acquired for development that they do not gravely impair the ecology and environment. Number 2, we also direct the appellant to incorporate the condition of allotment to obtain clearance from Karnataka State Pollution Control Board before the land is allotted for development. The said directory condition of allotment of lands be converted into a mandatory condition for all the projects to be sanctioned in future. My lord, para number 1 of para 100, sub-para number 1 of para 100 was the, my lord, issue for consideration before the learned single judge. What the learned single judge has said is, in view of this direction, before initiation of land acquisition proceedings, there should have been an environmental impact assessment study undertaken by the state, which is the acquiring authority, or by the board, which is the beneficiary of it. So, my lords, on that basis, some writ petitions have been allowed by one bench, and my lord, another bench has taken the view that, my lord, the condition that is, my lord, put by the Apex Court is complied if environmental clearance is taken even at a later stage. It is not a condition precedent is what the other, my lord, bench has said. My lords, here, what the learned single judge has done is, he has interpreted this direction as a direction to conduct environment study before initiation of land acquisition, whereas the Apex Court has only said that before acquiring the land, you conduct an impact assessment study. So my respectful submission is this. That is why, my lord, in this submission I have, my lord, just I gave to your lordship, my lord. This direction of the Apex Court cannot be construed as a precondition for initiation of land acquisition under the KID Act. It is only at the stage of, my lord, issuing final notification that it may have to be complied with. That is what has been interpreted, my lord, by the Apex Court in a later decision, Project Director's Case 2021, that has been.
National Highways.
Yes, National Highways Act.
Are the respondents also ready? Are you ready in the matter?
ಎಷ್ಟಂದ್ರೆ ವಾರ ಒಂದು 10%
We are starting it now.
ಓಂ ಪ್ರಕಾಶ್.
Before we start another matter, we are in the midst of a partnered matter. We thought we could.
It may be treated as partnered, my lord, your lordship may. In fact, my lord, we have made submission.
My lords have heard the matter. My lord, the only issue, my lords, there are two Supreme Court judgments. One in which KIDB is a part, in which there is a specific direction to KIDB paragraphs 100 to 104 to follow environmental clearance.
Before initiation of the proceedings,
Before
does
initiation,
the
yes.
judgment say so?
Yes, yes.
Does.
So that is one judgment.
Hmm.
They are relying on the National Highways judgment, where my lord's interpretation of section 3A to D of the National Highways Act, because there is a non-obstant clause under the National Highways Act, there they said that it can be substituted. Another aspect of the matter, my lords, is that insofar as this particular case is concerned, there is a government order which says absolutely no industrial development in that. So therefore, the chances of them getting an approval even post facto is next to impossible, because several people have tried. In respect of cancellation of their approval, my lord, several people have approached the division bench of this honorable court, and the matter is pending there, where the court has said nothing doing. KIDB is required to, KSPCB is required to ensure that there is no industrial area in it. So this is the nub of the matter is only on these two judgments.
No, we are only wondering, should this not go before the same bench?
It is not.
I'll make my submission, my lord. My learned friend is not correct when he says that the court has actually struck down the acquisition, etc. It's not at all there. In fact, my lord, in project director's case also, my lord, provisions similar to, my lord, the provisions of KID Act, where, my lord, in question. That is why section 3A of the National Highways Act, which is equivalent to, my lord, the section 28(1) was the subject matter. Section 2, subsection 2 of Highways Act, which is akin to, my lord, section 3(1) of the KID Act, my lord, was, my lord, an issue there. 28(1) was an issue there. 28(4), which is again 3D of the, my lord, Highways Act. They were all, my lord, similar, my lord, provisions. I mean,
Not the question, we're just thinking if there is another matter where the
I'll submit, my lord. What has happened is, my lord, 18/11/2003, the state, my lord, issued a notification after conducting environmental study in the, my lord, in respect of this Tippagondanhalli catchment area. And that was, my lord, at one point of time withdrawn by the government. That is what is questioned, my lord, in the public interest.
withdrawal is under challenge?
Yes, my lord, 24.
Withdrawal is under challenge.
Yes.
Withdrawal was challenged. Subsequently, my lord, that has been, my lord, the subsequent notification withdrawing 18/11 has been stayed and it is in operation. 18/11/2003 is now in operation, my lord. No.
That 28(4) also we can do it, or at the time of allotment.
Yes, ma'am.
They are saying you are impossible to comply in view of that notification.
That is what.
See, this cannot be any that unless that goes, then your argument will be hold to that.
No.
At this stage or that stage will not arise.
That is without any basis is my submission. 18/11/2003 notification, my lord, categorizes the Tippagondanhalli reservoir area into 4 categories. First category is a category where industries can be established, Zone 1, it is known as. In Zone 1, industries can be established is the notification, but it only prohibits over-exploitation of water. That is the only condition. My learned friend is not correct in saying that no industry can be established. 2, 3, 4. 2, 3, my lord, we cannot establish industry, Zone 2 and 3. Zone 4, my lord, again is a, my lord, zone where some industries can be established, like, my lord, orange industries or green industries, some industries are not permissible there also. So in project director's case, argument address was based on Kenchappa's case, my lord, where the present, my lord, order has been passed, my lord, relying on which, my lord, present orders have been passed. And the apex court has read down a 3-judge bench, my lord. The Kenchappa was, my lord, a 2-judge bench decision. 3-judge bench, my lord, in project director's case has read down that decision to say that at the time of issue of 28-1 notification, that is, my lord, 3-1 of National Highways notification, there is no need for any environmental clearance or study. And 2-2, that is, which is 3-1 of the KID Act, there is no environmental study required. Only before issue of 28-4 or, my lord, 3D notification, my lord, there has to be clearance for from the Environment Department, is what the court has said. And, my lord, in another case, subsequent case also 2022, the apex court has said that post facto environment clearance is also valid, is what the court has said in the case of
MSPL.
MSPL.
What was under the industry facilitation.
The direction in paragraph 1 of the KI 2006 371 that before exposition of plans for development, consequence and adverse impact of development on environment must be properly calculated. Must be understood to mean that the necessity of prior environment forest clearance would arise only if finally the land in question is to be notified under section 3B as being acquired for the purpose of building maintenance management operation. Such interpretation would further the cause of the objective. Therefore, it is at the stage of the final notification that this has to be taken into account. That is the only difference. It shifts from the preliminary notification to the final notifications. This is all.
And
But
even,
then
even
the
otherwise.
impact is something which must be taken into account, taking note of everything that is prevalent, including the notification by the state government. Is it not?
It is within the parameters fixed under, my lord, this notification dated 18/11/2013. All the lands, my lord, except the one, my lord, in which Mr. Shashikumar is appearing, according to him, it comes in zone 3. Rest of the lands are in zone 1, which permits, my lord, industrial activities subject to, my lord, restriction on over exploitation or exploitation of water. And, my lord,
Therefore, as of now, in the light of the interim order of stay passed, we can only consider it within the limits of what the notification says. Correct?
And
1811 is the notification. We must consider what is the position in terms of the notification by the state government of the area.
18. Yes.
Is all we can do.
And in fact, my lord, 891 acres is the total area acquired. What is involved in the litigations before your lordship is hardly 64 acres. And in the meanwhile, all clearances were, my lord, taken from the appropriate authorities and layout has been formed, my lord, allotments have been made, industries have been established after obtaining, my lord, all clearances laid down in Kenchappa's case. My lord, water treatment, sewage treatment plants are there, and my lord, all other precautions that are required for establishment of and running of industry have been, my lord, obtained by allottees. We have also, my lord, established some treatment plants there. My lord, everything is, my lord, now going on now. Now, if at this stage, if the acquisition is cautious, my lord, it will, my lord, paralyze the industrial development. And the other thing is that in some cases, the landowners have, my lord, asked for allotment of land under the land allotment policy of the state government, which provides for allotment of developed lands to the land users. In some cases, they have claimed compensation. In some cases, my lord, there is inordinate delay of 3 years, 3.5 years, my lord, in approaching the court. All these matters have to be considered, my lord, case-wise. Yes, some have not even filed objections.
Yes, we consider the merits of the matter. When will you be ready?
Next year. This place my file today. Some other court all there matter came out. Sorry.
Appearance.
Next week. Next year ready. ನಿನಗೆ ಮುಗಿಸ್ಬಿಡ್ತೀವಿ ಸುಮ್ಮನೆ ಇದ್ರೆ ಮುಗಿಸ್ತೀವಿ
Next week we may not have.
ಬೇರೆ ಮುಗಿಸ್ಕೊಡ್ತಾ ಇರ್ತೀವಿ ಅಲ್ಲ ಏನಾಗುತ್ತೆ ಇದು ಹೆಂಗ್ ಮುಗಿದ್ರೆ ಎಲ್ರೂ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ ಅದಕ್ಕೆ ಒಟ್ಟಿಗೆ ನಿಮ್ಗೆ ಲಾಸ್ಟ್ ಏನ್ ಮಾತಾಡ್ಬೇಡಿ 100% ಬಿಡ್ತೀವಿ ಇನ್ನು ಕಿರಿಕಿರಿ ಆಗುತ್ತೆ
21st, 21-2. Yes, yes. Of the senior counsel hearing, the appearance in some of these matters, the learned counsel for the respondents have sought time to place their arguments on record. List on 21-2. 2:30, we may have other matters at 2:30. Let it come in the list. If it is possible, we'll take it up. Yes. 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 Paragraph 3 says that as per lease agreement, plaintiffs have paid the lesser 50,000 as interest-free deposit. But as per the lease agreement, option has been reserved with the plaintiffs to buy the aforesaid land for a sum of 1 lakh, on condition that the plaintiff shall pay the balance 50,000 only. That the lessee plaintiff has taken the scheduled property. Where do they say that the rest of the 50,000 has been paid on that day?
But in evidence affidavit, the statement made by is 100 rupees, what they stated in paragraph. Page number 41. They contain that also an understanding and a payment of 25,000 was made on 1st of November 1973. 41 paragraph 8. Paragraph 8. It states that on 1/11/1973, I paid rupees 25,000 to the defendant in cash at his house in Bombay, and on 6/2/1975, that is on the date of registration of the inter-alia, I paid a further sum of 25,000
File check number 27. So here they say the payment was made by cash to the dependent. While at page number 74 and page number 73, they pay for it. Page number 73, from the top here, where you had transaction either by cash or by check with CH-3. I had one transaction with CH-3, paying 25,000 rupees when registered the lease deed of the scheduled form. Page number 74 bottom, I put it to you that the sum of rupees 25,000 paid on 6/2/1975 was paid to CH-3 in Bangalore and not to the dependent. He says it for further, he is telling that I paid rupees 25,000 to CH-3 by check from Mysore SP or Mysore Maharashtra. Program to show that the entire amount was received by the GPA holder at no point of time. There is no receipt to show that the defendant has actually received any amount. And also, to page number 7. Page number 7 of the paper. Exercise their option to purchase the scheduled property, though the defendant assured the plaintiff orally, as well as in writing that he would execute and register the same in their paper. For reasons best known to the defendant. Here he states that for reasons best known to the defendant, the deed was not executed. While at page number 46 in the evidence affidavit, page number 46.
Yes.
On the property is 10th line. Sale deed attract payment of capital gain, and the defendant, as he has executed some sale deeds in favor of others, he will have to pay huge capital gains, and classifiedly saying that as I already constructed the house on the scheduled premises and living in the house, he will execute the sale deed after sorting out his tax problem. So by filing the evidence affidavit, he includes this case. And also at page number 43. Page number 43 from the top, the defendant told me as in his building construction work, he has entangled his tax problem. It is not possible for him to obtain income tax clearance certificate in the near future, and therefore execution of sale deed is to be delayed. Page 42, another mission made by the plaintiff. In the first week of February 1976. I told the defendant that I am exercising my option to purchase these scheduled premises, and the balance sale considered or balance sale price will be paid on the date of registration, and requested the defendant to fix the date for registration. Here he goes on to say that he intends to make the entire payment with respect to the total consideration on the date of registration. While elsewhere during the cross-examination, he said that everything was paid before 1981 itself. And also there is no meaning with respect to when he expressed his intention to opt for purchase of the property in the bank. Nowhere he says as to when he exercised that option. The bank is entirely silent about it.
Checks issued by me have been encashed by the defendant. There are entries to that effect in the passbooks.
Yes,
Certified copies, bank passbook, P78, P9, P10. Relevant entries are marked as P78, P8A, P9B, P10B. Defendant has issued stamp receipts duly sent for having received the rents from me 1477 to 31 with 81. Receipts are P11. Signatures. Yes. Paper. Yes. Page number, please. Documents is separate. These are only pleadings. Another paper book. Documents. Paper book of exhibits. Page number 160. Just 1 minute, please. Take us one by one. You said 160. We are going to 160. And after that, you can tell us whatever else you want us to go. 160 is not, 160 is the last page of the power of attorney. One 160. It's from 16. Andhra Sugars. Parallel, these are all the tax documents.
Please, my learned friends has filed a cross objection. I think
Volume-
there's,
First set, volume number 2. There is a volume number 1 for this. This will have a volume number 1. Eight. That will be volume number 1.
I filed 2 paper books. One contains the exhibits. That's also here. My friend has that. I'm sure I can lend my copy here also. This as well.
For confusion. Yes. 160. Dr. K.S. Ashok and Ranganayagi Ashok.
Here,
in this deposition, this is a bank statement with respect to the plaintiff and his wife. Passbook has been produced, and the passbook is a photocopy. The original document has been placed before the bank. This is forthcoming in the judgment, page number 227. Page 227, the learned trial court judge also makes an observation that the document which has been marked with a photocopy. And in this deposition, at page number 75 of his deposition, he states that it is the joint account of his and his wife. And also, exhibit P4A, a check has been issued in favor of J.R. Sheshadri, who is the GPA holder. And even with respect to that, at page number 76 of his deposition, the plaintiff admits that he is not sure as to who gave the check to them, who gave the check to J.R. Sheshadri. He says that it was given by him, but then he clarifies saying that he does not have any record to prove that. At page number 76 of the deposition. Exhibit P6 in joint account that has been admitted by the plaintiff at page number 78. While in his pleading, he says that everything was transferred solely from his account, but the documents speak otherwise. Exhibit P7 as noted. The account belongs to plaintiff's daughter. Exhibit P7. Information with respect to that is forthcoming at page number 79 of the deposition.
What does he say?
Exhibit P7 account is not your bank account. He says yes. And exhibit P7 does not show that you are the PA holder of your daughter. No. And also you did not issue the check under exhibit P7A. I have signed the check as PA holder to my daughter. That's what he said. But no document has been produced to support that. And exhibit PA, he himself admits that he's not sure as to what the, to whom the document, the passbook belongs to, which is forthcoming at page number 80. Page number 80 from the top fourth question. Exhibit PA bank account stands in whose name? It is standing in the name of Arvind Ashok Sheshadri. Exhibit PA and PAD do not contain the name of the account holder. Yes. So the name of the account holder.
What about the receipts that you have issued?
The receipts were all issued by the GPA holder and payment was made to the GPA holder.
KD Sheshadri received from Dr. K.S. Ashok total sum of so-and-so towards lease rent of property leased to him over the period of 12 months on various dates at so-and-so per year. KD Sheshadri. P10. That is not to the PA holder. It is to KD, it is issued by KD Sheshadri himself. P10, P10A, P10 B, P10 C, P10 D.
And these, if I may bring your lordship's attention to page number 82. There is a deposition with respect to exhibit P10. Exhibit P10 relates to the payment of rent for 48 months. Here he admits that it was rent and not a sale consideration.
That is not intended as sale consideration at all. He says rent was paid specifically to you. At least part of the rent was paid specifically to you.
No, the entire document was prepared by him, Your Honor. He even says that the document was typed by me. The receipts were typed by him.
B11 is a receipt by the power of attorney holder.
And page number 82 is the relevant page with respect to exhibit B8.
Hmm.
Exhibit B10 receipt typed on the same way, maybe probably. Question, apart from exhibit B10, you have any material to show that you have paid the rent? I have no other material evidence except exhibit B10. How do you get the source of exhibit B10? Mr. J.R. Sheshadri had kept all the rental account, which I had paid on various days. On that basis, I prepared exhibit B10. You don't have copies of rental account, I don't have. Where are those documents on which you relied to prepare exhibit B10 by Sheshadri? I don't know. You have typed exhibit B10 purely on the information given by the J.R. Sheshadri? Yes. In such case, J.R. Sheshadri also have been examined your work. J.R. Sheshadri is still alive? Yes. Though he was alive, he was not examined at all by the patient.
What about P16?
P16 was again bring your lordship, page number 87.
Hmm.
There's a question with respect to exhibit P16.
Hmm.
From the top, 87. Where do you get information for preparing exhibit P16? I had checked the records, copied it from that. Previously, he said that he got all the information from J.R. Sheshadri, but contravening what
That is
he
with
said.
regard to rent.
Rent is-
This is the consideration, sale consideration.
So he later says that the rent has been converted to sale. That has been his argument. Whatever that was paid between 1976 to 1981 as rent was later he chose to treat it as sale consideration. That has been his case.
Where does he say so? I don't think there is such a case. Where does he say so? Where is that contention taken? The contention is that until the entire sales consideration was paid, he had continued to pay rent. After the entire sale consideration was paid, he made the request for the deed to be executed. It was not done. Yes, he sent the draft, you signed on it and said, okay. This is the contention, not that rent has been converted.
Please. That was part of the agreement that I had to do that. I had to demolish that structure that was on the property. I built my own house there.
All the cash payments made in also with respect to all the cash payments made in exhibit P16. Mainly admits that there is no receipt with respect to the cash payment.
I, K.D. Sheshadri, confirm that I have received a total sum of rupees 1 lakh stated as above from Dr. K.S. Ashok and Arvind Ashok Sheshadri, being the total consideration value of the property leased to them towards sale at their option is P16. What do you say about that?
Have denied our signature.
Where do you say? Where specifically do you deny it?
€148, page number 148. I'm not liable to execute sale date as demanded by the plaintiffs, and I have not received any consideration from the pages as attached. I submit that I have not issued any stamp receipt for a sum of rupees 1 lakh to the plaintiffs. The said receipt is a forged document. I submit that I have not issued any stamp receipt for any rentals from the period, for the period November 1973 to December 1991 as alleged in the suit. The receipts are the forged documents. The document has not been admitted.
P17 letter also denied.
Again, this document was typed and prepared by him.
The letter.
And here your lordships, I mean, read the letter. As per the registry dated 6 February 1975, a sum of rupees 50,000 was to be kept as interest deposit with me on account of the above mentioned plot. It was further agreed between us that I would sell the said premises to you for a price of 1 lakh, and the deposit of rupees 50,000 paid by you would be treated as part of the company. Since the execution of this deed, you have paid me the balance sum of rupees 50,000 also, making the total amount paid by you to me as rupees 1 lakh. I shall execute a conveyance deed for the lease premises in your favor at any time desired by you. I have received all the rents up to date from you, and there is no rent is payable by you now. With respect to the case number 18. Here again, question was asked if he typed the entire document, and he admits that it was typed by him and it was prepared by him. And also, there's one more thing that needs to be observed. This document was prepared by the plaintiff, wherein he states that K.D. Sheshali is the karta of the family. Under K.D. Sheshali, there is karta for Doraswamy Sheshali HUO. Exhibit P18 has not been signed by the defendant.
Not signed.
It is not signed by the defendant.
Signed only by Ashok.
Only by us. Even PW3, the CA of the plaintiff, even he admits that he's never seen this document. But on the contrary, plaintiff has stated that this document was prepared in presence of. Again, this document was, exhibit P19 was issued by one of the CA on behalf of Ashok. And this document again has been denied by the defendant, Your Lordship. And the same is forthcoming at page number 94.
P19 is between the plaintiff and the chartered accountant.
Yes,
It has nothing to do with the defendant. He need not know it.
This was prepared much later. That was after the filing of this.
Yes.
Exhibit P20 is the draft sale deed. And here also there is no signature of defendant.
Okay, signed 5/11/95. That is what they rely on. They say it is initial by you
Okay.
and okay.
But during deposition also that has been denied by. Page number 96.
Yes.
The correction, page number 96. That the correction set out by you or pointed by you, not initiated by the defendant. This is corrected word, not initiated. that it was, that get, okay, it also is a object. Inter-particular.
Yes.
Exhibit B29. That is the GPA.
Hmm.
This document is not a registered document. It only enforces the document. And also, there's a clear admission by the plaintiff himself that page number 1 and 2 of the GPA have not been signed by the dependent here. Exhibit P29, page number 216. And the deposition with respect to that is at page number 98. Page number 98, at exhibit P29, comes the top second question.
Yes.
Exhibit P29 at page number 1 and 2 does not contain the signature of the defendant. This page number 1 does not contain the signature of the defendant, but has the defendant initial correction. Page number 2 has not put his signature. So our case has been that page number 1 and 2 have been replaced by the plaintiff's hearing. And page number 2 contains the recital with respect to execution of sale deed and sale deed. Though the deed was not registered, at page number 10 of the deposition, you have come to top question number 4. Exhibit P29 is not registered in the office of the sub-register. It has just attested. It says, I do not know. Exhibit P38, the word okay and initials are not that of the defendant. It was given to me by PA holder of the defendant. So even he is not sure as to whether okay are the initials of defendant or not. Exhibit P35 is the photograph.
That is the photocopy. Defendant, his wife, and the power of attorney holder.
Defendant and his wife.
And the power of attorney holder is also signatory. Document has 3 parties, not 2. Not correct, counsel. Please see page 254. 1 and 2 are KD Sheshadri and his wife. Whereas the scheduled properties in occupation of JR Sheshadri, son of KT Rajan, cousin of KD Sheshadri for the last 10 years, who has also made a party to this partition. 3 persons.
Exhibit P39 is another examination to another studio. That relevant page is 269. 269 paragraph number 3. Paragraph number 2 from the bottom 9th or 10th line. I have not executed any power of attorney in favor of defendant number 2 for sale of scheduled property. So here the defendant is J.R. Sheshadri.
Defendant number 2 is not having any right or interest over properties 7/3 and 7/4 to negotiate sale of those properties. To my knowledge, defendant number 2 has not negotiated the sale of property bearing 7/3, 7/3 or 7/4. I have executed GPA in favor of defendant number 2 in the year 74 in connection with property bearing 7/1. During the year 74, part of property was leased to one Dr. Ashok. In that connection, I have executed power of attorney in favor of defendant number 2 to execute lease deed. As I was unable to come over to Bangalore from Bombay, I have executed the said power of attorney in the office of the sub-registrar Bandra, Bombay. At the time of execution of the power of attorney, defendant number 2 was present at Bombay. I sent the power of attorney to Ashok to get the lease deed registered from defendant 2 in his favor. I instructed Dr. Ashok to retain the said power of attorney with him after he got executed the register. Was in respect to the property leased to KV Jera, where you say 7/1 I had executed a power of attorney. On the basis of that power of attorney, lease deed and sale agreement was entered into in respect of 7/1 to Dr. Ashok.
Yes. But what we are saying is that permission to sell the property was not given. Your doctor, after examination of the you pay that 127. Whatever the decrement is the only son to his father. It means that the property is involving upon the dependent. It is true that it is the ancestor property in the hands of the dependent. It is true that the property mentioned in exhibit P34 includes property also. It is true that there is the recital in exhibit P34 that all the original documents are handed over to me. Now the witness volunteers that the original documents have not been handed over to me. Only the corporation allotment order was handed over to me. That the property is denied by the plaintiff. Page number 130. Page number 130, last paragraph. It is true that we have signed as attesting witnesses to exhibit P18. And also it doesn't contain the signature of defendant as an exhibit. It confirms the fact that defendant was not a signatory to exhibit. And India Lordship attention for cross-examination of PWC, page number 135. Plaintiff elsewhere has stated that PW3 was privy to the transaction between the parties and also he was responsible for exhibit P18. But here he states that I have not at all seen the document exhibit P18 prior to this day or after this day.
Who's PW3?
The CA.
Aranason.
No, Venkateshwara. TV Narayan. Page number 137. From the top, 11th line, the last payment was made on 1/11/1970 as per exhibit P38, only on the basis of exhibit P38. I am disposing about the consideration paid by Dr. Ashok, but I do not know personally about the consideration amount paid by Dr. Ashok. The PW1 Dr. Ashok did not pay the tax on the basis of the market value in the year 1995 at rupees 1,27 lakhs. As on 1995, the value of the property was almost 1,27 lakhs, and even the plaintiff himself admits at property valued somewhere between, even in the worst case scenario, it was somewhere between the range of 40 lakhs to 60 lakhs. My submission is that your lordships, in 1975, even if we were to believe that the lease deal could be treated as a lease cum sale agreement, we ought to have exercised the option at the earliest point of time. And from 1981 to 1995, it does not issue any notice, does not call upon the defendant hearing to execute the sale deal at all. He remains silent from 1981 to 1995. And during this intervening period, he ought to have shown his willingness and readiness to execute the sale deal. Except for a broad statement that the defendant was avoiding on the pretext that text of capital gains and income tax. There's nothing else, no document has been produced by him. In fact, he even admits that there's no written statement given by the defendant with respect to capital gains or any issue with respect to tax liability. Page number 144.
Of
140. The event, admittedly, the said power of attorney exhibit 29 does not contain my signature. At page 1, my apologies, this is the deposition of dependent number 1, dependent AD Shesha. In any event, admittedly, the said power of attorney exhibit P29 does not contain my signature at pages 1 and 2. The initials at page 1 and 2 in exhibit P29 are not mine, but were forged by the first plaintiff. The first plaintiff replaced the pages 1 and 2 of exhibit P29 and thereby introduced the clauses fraudulently and without authority detrimental to my interest. I never gave consent of authority for the aforesaid clauses of option to purchase for a sum of rupees 1 lakh as paid by the plaintiff.
P29 the original records.
That the document would be treated as a lease deal, but even the judge goes on to hold that the document is not even lease deal and goes on to declare that the document is null and void. But while the defendant sought for partition, he relies on the lease deal and he states that they ought to have issued a notice under the provisions of Transfer of Property Act. Once the document have been held as null and void, the question of issuing the termination notice is not arise. Case. The plaintiff admits that there was a partnership formed where the defendant and plaintiff's wife were partners to the said firm. So whatever, which is at page number 72, deposition. There he admits that there was a partnership form called Registry and Co. And both defendant and the plaintiff's wife were partners to the said firm. And we have specifically stated that some of the amounts transferred from the wife's account was with respect to the partnership and had nothing to do with sale. It is forthcoming in page number 72 of PW1's report.
This power of attorney has been executed by Sri Kumar Doraisamy Sheshadri, presiding at so and so, Gary, Bombay, in my presence on 9/12/1974. His identity is proved by Sri G. Giridhar. Handwriting of Identifying the principal. Signed and delivered by the within named Kumar Doraisamy Sheshadri. The presence. 26 September 1960. Received notification contains one interlineation page. Yes, P29 provides that there is received authentication fee of rupees so and so. This power contains one interlineation at page number 1, date 9/2/1974. There is one interlineation at page number 1. Yes, the stamp paper is purchased by you, admittedly, KD Sheshadri. You sign the third page, and where the part of it, I mean, where the sub-registrar authenticates it, he says this power contains one interlineation, page number 1. There is one interlineation in page number. Difficult. It's there. In the documents, it's there. Absolutely no insertion. It is only a smaller paper because it is a stamp paper. Negotiate, fix the price, sell or lease the lands and buildings in one lot or separately upon such terms and conditions that he may deem fit, receive the sale proceeds or lease rents, give effectual receipts thereof, to execute and sign such sale deeds or lease deeds and get them registered, execute any other documents as may be necessary. Sold by the stamp vendor to you on 26 September 1970. Document is executed and identified on 9/12/70. Anything else? And anything else, your contentions in a short synopsis, please.
I'll also be having it tomorrow. I'll also be having this tomorrow.
Tomorrow? Let's.
Court officer? Court officer?
ಸರ್ ಹೇಳಿ.
Sir, ಇದು ಲಿಸ್ಟ್ ನಂಬರ್ 3.
ಹಾ
ಲಿಸ್ಟ್ 3 ಏನು ಬರ್ಲಿಲ್ವಲ್ಲ ಸರ್?
ಹಿಸ್ಟ್ರಿ ಯಾವ ಕೇಸ್ ನಂಬರ್ ಸರ್?
Yes, 22 sir.
22.
Yes sir.
22 20th February.
20th February. Okay sir.
Yes.
Sir, serial number 27, sir.
27 na? List 3 na?
List 1, sir.
List 1 13th February madam.
Okay, sir.
Sir, cause list 1 serial number 30.
Sir, list number 130 na?
ಹೌದು ಸರ್.
ಯಾವಾಗ ಬೇಕು ಸರ್ ನಿಮ್ಗೆ?
ಈ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರಾ ಸರ್ ಅಥವಾ ಕರೆದಿಲ್ವಾ ಇನ್ನ ಅದು?
ಕೊಟ್ಟಿಲ್ಲ. ಯಾರಿಗೆ ಸರ್ ನೀವು?
ನಾವು ಪೆಟಿಷನರ್ ಸರ್.
ಅಪ್ಪಲೆಂಟ್ ನಾಗೇಂದ್ರ ನಾಯಕ?
ಹೌದು.
ಸರ್ 19th ಆಗುತ್ತಾ?
19th.
19th.
ಹಾ 19th ಓಕೆ ಸರ್.
ಹಾ ಓಕೆ. 26 ಸರ್ ನಿಮ್ದು? ಹಾ ಈ ಗುರುವಾರನಾ ಸರ್? 6th ಆಯ್ತು ಸರ್.
6 ಸರ್ 19th ಕೊಡ್ಬಿಡಿ ಸರ್. 6 ಇರ್ಲಿ. 6
32 ಯಾವಾಗ ಬೇಕು ಸರ್?
6 ಇರ್ಲಿ ಬಿಡು. 6 ಆಗ್ತದೆ.
ಹಾ ಒಂದು ನಿಮಿಷ. 25 ಕೊಡ್ಲಾ ಸರ್? ಹಾ
ಸರ್ 25 ಕೇಳ್ತಿದ್ದೀರಾ?
32 ಅಲ್ಲ? 32 25ಕ್ಕೆ ಸರ್. ಓಕೆ.
Sir, serial number 27. 12th ಕೊಡಿ ಸರ್, ಇಲ್ಲಾಂದ್ರೆ post 20th ಕೊಡಿ ಸರ್. ಸೀನಿಯರ್ ಅಲ್ಲಿ ಟೌನ್ ಅಲ್ಲಿ ಇರಲ್ಲ ಸರ್.
ಮೇಡಮ್ ಅದು ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿದ್ದು ಆಗಿದೆ. ಅದರ್ ಸೈಡ್ ಬೆಳಿಗ್ಗೆನೆ ತಗೊಂಡೋಗಿದ್ದಾರೆ ಮೇಡಮ್, ಈಗ ಚೇಂಜ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಓಕೆ ಸರ್.